Yes.
Lordship, daily list item number 32, Lordship.
32, yes.
Matter may be taken after 2 weeks, Lordship.
Okay. Who are you? Yeah? For the petitioner?
Yes, Lordship.
What is your name?
NJ Begum, Lordship.
Miss, on the prayer for adjournment made by Miss N.J. Begum, Learned Counsel for the petitioner. List the matter after
2 weeks.
2 weeks.
I on behalf of D, we have item number 3 on the pass over for that. Next week, anytime.
This is why adjourn?
Unfortunately, this matter may be in factual because he has filed another writ petition subsequently.
Then,
For today,
huh?
he telephonically informed me that only for today prayers may be made
Right.
for it.
On the prayer for adjournment made by Mr. D. Buya. List the matter day after tomorrow. The matter pertains to the rejection of the petitioners, the rejection of the application for compassionate appointment being submitted only in 2022 when the father had died in 2014. Tell him 8 years after cannot. So we know the facts of the case. Yes.
Lordship, I beg to mention item number 26, my lord.
Yes.
In this case, my lord, affidavit is ready, my lord. We have sent it for vetting, my lord. Matter may come after
26. Okay. Miss S. Learned Counsel for the petitioner for the
respondent, my lord. Elementary education.
Elementary Education Department submits that the affidavit has been sent for vetting and the same will be filed within
Next week, my lord.
within a week. List the matter after a week.
Due vacation.
This is the matter after the bill vacation.
I am for the petitioner, my lord. I am for the petitioner. In this case, my lord, interim may continue, my lord.
Interim order to continue till the next.
Obligation item number 15, Lordship. This matter may pass off for the day, Lordship, can be taken after vacation.
15.
I do not. Can I get for you?
Yeah, adjourning the matter all the time because you've got a stay order. You have seen the last 4 orders all adjourned because of you. You have got a stay order because of your date of birth.
Yes, Lordship.
Yeah. As per the records, you are supposed to have retired in 2018.
No, Lordship.
Now you are claiming 27.
That is based on the.
Correct. So we no further adjournment. We'll take it up.
That's why I beg to mention item number 13, Lord.
Item number
13, Lord.
13.
13, Lord.
Yes.
Conscience of the other side, Lord. I'm praying for the adjournment of the matter for the.
You are for respondent number
Respondent number 4.
4.
Lord.
Okay, right. Who's for the other side? You have taken the consent of the petitioner?
The consent from the petitioner side.
Okay, Mr. What is your name? Huh?
BK Gogoi.
BK Gogoi, Learned Counsel for the respondent number 4, submits that. He has taken the consent of the other side and prays for adjournment. List the matter after the vacation.
My lord, praying for listing of 2 matters for listing, my lord.
For
listing matter,
admission,
admission.
go to the registry.
No, Khabar case, my lord.
Huh?
Khabar case. Khabar case.
Covered by what?
My lord, covered by earlier judgment, my lord.
Which judgment? Regarding what?
Well, no, regarding 1 B.Ed increment, my lord.
Huh?
1 increment for B.Ed, my lord. 1 increment for B.Ed degree.
You go to the registry. Yes.
Item 18, Lordship. Could give consent of the other side. For the respondent. I'm respondent 9 and 10. I'm for the petitioner, my lord.
No, any objection?
No.
Okay, right. On the prayer for adjournment made on behalf of the council for the respondent number 9 and 10.
File affidavit, Lordship.
Huh?
File affidavit, Lord. This is my.
Who submits? You will file it.
We will file.
Who submits that he will file affidavit within within a week. List the matter after the vacation. Full stop. The matter pertains to whether the petitioners or the respondents number 9 and 10 are the actual teachers.
Yes, my lord.
May please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 20 of the daily list, my lord, on behalf of Mr. D. Borua and Mr. P.K. Bordello.
Okay, right. On the adjournment prayer has been made on behalf of Mr. D. Barwa, learned counsel for the petitioner.
My lord.
The matter pertains to the claim for regularization on the ground that the petitioners have been working as lecturers, have been working uh, on contractual basis since 2007. List the matter after vacation.
Obliged.
May I please your lordship? I beg to mention item number 11.
11. Yes.
Due to medical reasons, my senior counsel is out of station. Please kindly adjourn the matter. Okay, please.
2015, father died.
My
Okay,
lord,
right. Adjournment prayer has been made on behalf of Mr.
it's a lost cause.
H.A. Laskar, learned counsel for the petitioner. So the matter pertains to the challenge made to the notification dated 18/9/2024, wherein there has been a ban on compassionate appointment in respect of the family of the government servant who died prior to 1/4/2017. On the prayer of the petitioner's counsel, this is the matter after review.
May it please your lordship. I pray for listing of one petition for orders, your lordship, on 9.
Registry matter.
TPM.
May I please your lordship? I may be allowed to withdraw the present petition which has liberty to file a case.
Okay, right. Mr.
L.K. Bora.
L.K. Bora, learned counsel for the petitioner. I pray that he may be allowed to withdraw the writ petition with liberty to file afresh. Mr. P.K. Bora appears for the Elementary Education Department. Prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn. With liberty as paid for.
Lordship, matter may be taken up after some time.
What is to be done? Well, anyway. Okay.
Item 4.
The lordship would allow.
Huh?
The lordship allows, can the matter be part after some time, your lordship, my senior would.
Item?
4, the contempt matter.
What about item 3? Yes, sir. Yeah. They didn't pray your prayer. Okay. Okay, right. Okay. Okay, right. Okay, that one. Okay, right. So what do you want out here?
After some time, your lordship, my senior would be here. My name is not reflected in the process.
Next.
Item 5.
My pleasure.
Heard, Mr.
K.I. Mazumdar, my lord. I am on behalf of J. Abedan, my lord.
A.I. Mazumdar, appearing on behalf of Mr. J. Abadin, submits that the petitioner has not been considered for provincialization till date in terms of the order dated 15/2/24 passed in WPC 257/24. Issue notice returnable in 4 weeks. Petitioner will take steps within 3 days. List the matter after 4 weeks.
Item 6.
May it be pleases your lordship. Here, your lordship, some clarification is shout for on behalf of your lordship, DSC. So kindly grant us 1 week time, your lordship.
Madam, you are always asking for time. Time and again you're asking for time. What is it?
Your lordship,
Some
that
excuse
instruction-
or the other is
that
coming up.
instruction is not clear, your lordship. Which I received yesterday.
Let us see your instruction. Every day, every time is being listed, you're saying 1 week, and adjourning it for some reason or the other. This is on 1/4. Now it's, what is today's date? 2/5. 1 month has gone, madam.
One.
Right. Ms. P. Das submits that the directorate received the area proposal in respect of the petitioner from the inspector of schools by letter dated 24/3/2025. However, as several discrepancies were detected, the inspector of schools NDC Nagaon was requested to resubmit the area proposal along with all relevant records, which have not been submitted. As such, time has been paid for. As the inspector of schools NDC Nagaon has not submitted or what? Has submitted or not submitted? You have got no idea.
Your lordship,
Fresh area proposal has not been submitted, Loki. It was sought only yesterday.
Has not been submitted by the inspector of schools. Gustav. The Ms. P. Das Nipara shall on the next date inform this court as to why the inspector of schools has not submitted a fresh area proposal pursuant to the letter dated 1/4/2025 issued by the Director of Secondary Education itself.
your lordship, this instruction received yesterday only, 1/4/2025. Today is 2/4.
That is why we are going to ask the director and the inspector of schools, not you. You all are only the face of the director and the inspector of schools. Okay, list the matter on next week.
Yes.
Give a date.
Appearing for the AG.
Huh?
I'm appearing for the AG.
Mr. B. Sharma appears for the AG. Assam. Right.
Deeply obliged.
Item 7.
My lord, I have got the election from the Guwahati University, my lord, as to the appointment of the principal, my lord.
Huh?
As to the appointment of the principal, my lord. It is by the governing body, my lord. It gets clarified by the Guwahati University itself.
Yes. So according to this academic registrar, what university, the principal of a private B.Ed college is appointed by the president.
Yes, my lord.
So
But-
what remains?
My lord, as per the NCT website, where I have found that the parent body which sponsored the college and got the recognition, that president and secretary of that parent body is the power, has the power.
Where?
My lord, that is at the time of, my lord, application to college, my lord.
At the time of initial
Yes, my lord.
establishment
Yes,
of the
my lord.
college.
Thereafter, when the governing body is formed, my lord, that parent body goes, my lord. Parent body has no role, my lord.
Parent body always has.
Only, my lord, they can nominate only 4 members. That is not mandatory also, my lord.
Show me. Yes, where?
This is the, I have found from the website of NCT.
Where?
Last portion, management role.
According to the NCT, the appointment of a private B.Ed college principal is the responsibility of the institution's management,
Yes,
following the recommendations of a duly constituted selection committee as per the policy of the sir. So
Yes.
it's the management.
yes.
You are
management-
sponsoring authority is not the management.
Management is defined
Oh.
on the last part, my lord.
Last part is what?
Management means trust or society.
Management's role, the management is institution management, example, society trust is responsible. Which
Another-
where?
Another form is there, my lord, when all the staff and teachers have to submit before the competent authority. Here it is specifically written in the note that the institution shall submit the above list as per the provisions of the NCT Regulation 2014. And the last part, it is written that the above details shall be signed by the Secretary President, Chairman of the concerned management.
That is initial part. Before formation of the governing body. After formation of governing body, my lord, issuing body has no role.
Yes, where?
I have marked it, my lord. This is the form has to submitted by the only teachers and staffs.
This is for what? Yeah, just giving bits of pieces of paper from here and there. You have not even given the initial portion of it.
Required format of NCT to be submitted by the appointed teachers and staffs.
But where is the role of the sponsoring body?
It is, my lord, in the notification itself said that I have earlier submitted also, my lord.
Heard Mr. S. Hawk. Yes, where is the authority of the deputy commissioner to appoint the in charge principal of the college? Yes, Mr. Deary. Where is the authority of the deputy commissioner?
Lordship, on earlier date also, I have furnished the communication, that means on the facts and circumstances we are bound to interfere. And meanwhile, they have.
You have furnished where is the document that you have furnished? You have taken it back,
Recently, yesterday, they have furnished me one
or they have
communication.
furnished you? To be their reply or notice addition. As per the NCT rules. Show me as per which rules?
My lord,
Have you got this?
no, my lord, it is clear violation of Article 19(1)(g), my lord. They cannot interfere. my
As
lord.
per as per the NCT rules, the administrative and financial power of these private colleges which are not covered are under the control of the sponsoring body, which is reflected in the notification dated of NCT clause. Where is this, Mr. Council? I'm not asking you, Mr. Council, you sit down. Hey, you sit down. I'm asking Mr. Deary. Yes.
Uh,
In any manner, they cannot interfere with the autonomy of a private institution.
If you think about it, we'll take it up at 2.
Lordship, here, though I have not brought the concern material, but I have brought it from my friend. That,
You have brought it from your
yeah,
friend. Okay. Good.
November. The next page.
Next page. Where? Eligibility.
See.
Huh?
That 4D, your lordship.
We'll take it up at 2 o'clock. Okay. We'll take some time. Okay. Next.
Time being, I think 4.
Yes.
Please, your lordship. Well, there is a contempt petition, my lord, only notice to be issued. The order which has not been complied with, your lordship will find the effective part at page 30. Please.
Okay, right. Heard Mr. M.K. Chaudhary, learned counsel for the petitioner who submits that the benefit of the ROP based pay. What is this? Which ROP?
My lord, no, they were, my lord, given they are contractual employees. The regular pay scale was sought to be given, my lord.
Which ROP?
No, that has not been.
But that is the word used by the
Yes, my lord.
in the order.
Yes.
That does not say regular pay.
No, my lord, what happened, in spite of this order, now they say that you will not be getting any pay, any regular pay. That is.
So, but the order does not. What does the order say? Let us see. Page
30, my lord.
page 30.
No. Paragraph 19.
It says there to extend the benefit of the ROP based pay. Which ROP?
No, the ROP, my lord, that has been discussed earlier. ROP can be of any year, my lord, that doesn't matter.
How can it be?
No, because, my lord, they were not getting the regular salary.
Anyway, right. Who submits that the benefit of the ROP based pay and other service benefits have not been provided to the petitioner. Petitioner in terms of the order dated 18/12/24, passed in WPC 19/16/23. Issue notice returnable in 4 weeks. Steps within 3 days. List the matter after 4 weeks.
Compliance.
May it please your lord.
Where is the case?
Yes, there is no case.
No case.
No, yes, I understand, my lord. I understand. There is no case. I'm aware about the present situation of the settled provision of law, but what my respectful submission would be, my lord, if lordship is pleased, lord, subject to what lordship would say, we can make some distinctions considering the fact that all along this person was, or the family of this petitioner was, my lord, prejudiced by some perverted actions of the department.
You see, the mother can challenge. The mother can challenge. Because the overage happened, if it happened during the pendency of the application, the mother can challenge. The son cannot.
No, my lord,
You see, the cause of action doesn't devolve upon the son. There is no question of transferring cause of action from the mother to the son. The father died 2014. Mother applied. Mother application rejected. Now the son has applied.
that is one aspect. I agree to your lordship.
And
I am not-
the son rejected. Son application
No,
not rejected.
no,
You want it should be considered.
My lord,
No case.
my lord will appreciate. If lordship would,
I can understand if the mother says that during the pendency of the application, I became overage. Then we can say, okay, age will not be a determining factor. That we can say. But not the other way around. Because what will happen? Once they get compassion appointment, they are allowed to work till 60. There is no question of overage till you are 60. So if you want, the mother can apply and challenge the rejection on whatever grounds, if it's germane, that's a different thing. But the son has no case. No, that we cannot. And that also, when did he make the application, son? When did he make the application?
when our mother's case was rejected,
When was that?
it was rejected, my lord, the fourth DLC was held on 7/3/24.
7/3/24. So that means he applied after 10 years.
May I pray, my lord? If lordship allows me, my lord, let me withdraw these applications. I would come in the name of the mother.
You withdraw. That's a different thing. You heard Mr.
HMO,
H. Amwal, counsel for the petitioner, who prays that he may be allowed to withdraw the writ petition. Mr. P. Saikya appears for
Deputy Commissioner.
the Deputy Commissioner, while Mr. A.R. Tamildar appears for
Higher Education Department.
Higher Education Department. The prayer of Mr. H. Amwal is allowed. Writ petition is dismissed as withdrawn.
Oblet.
In this case, the notice may go, my lord, are similar.
Okay, just write the facts of the case. Mr. Chama, just the facts of the case. The petitioner's cases that the petitioner's father died in harness in the year 2014. The mother applied for compassion appointment. However, the same was rejected due to being overage. Full stop. The son of
While mother applied, my lord, while mother applied, then she was within the age.
And that's a different thing. I'm not saying anything. However, it appears that the mother of the petitioner was within the age limit at the time of filing the application for compassion appointment. Full stop. The son has now made an application for compassion appointment due to the death of his father in 2000, made an application for compassion appointment in the year 2024 after the death of his father in 2014. Then you're right, huh? Mr. Senator, then.
Well,
Oh, nice.
My lord, regarding my lord, new pension to old pension, notice was issued or lordship. Notice.
Okay, right. Mr. N. Bora, learned counsel for the petitioner submits that the petitioner has been accommodated as a tutor,
Tutor, my lord.
right, order dated
By order dated
30/01/2021.
31/2021.
31/21.
21.
He submits that as the petitioner had been initially appointed in the year
1989, madam.
1989, he should be governed by the
Old pension.
Assam Service Pension Rule 1969 and not by the new pension scheme. Issue notice returnable in 4 weeks. Mr. P. Kaushik accepts notice on behalf of
On behalf of my lord, response number 1, 2, 3, 4, and 5.
1, 2, 3, 4, 5. While Ms. R.M. Barua accepts notice on behalf of point number 6. Release the matter after 4 weeks.
Then.
May I please, Your Lordship? Matter leads to non-payment of family pension. In 1996, the petitioner's husband was appointed and subsequently he continued his duty. And
Regularized when?
on 22/3/2001. Your Lordship will find it.
Okay, right. Heard Mr.
R. Bora, Lordship.
R. Bora, learned counsel for the petitioner who submits that the petitioner's husband
Lordship.
was regularized in 2001 and died in harness
Lordship.
on 28/11/2023. However, the petitioner has not been paid, has not been given the family pension till date. The petitioner's counsel submits that the petitioner's husband died while serving as a lower primary teacher. Issue notice returnable in 4 weeks. Miss J. accepts notice on behalf of
4, 3 and 4 lots.
3 and 4, while Miss S. Kutia accepts notice on behalf of 1 and 2. Miss R. M. Barwa accepts notice on behalf of respondent number 7, while Mr. P. Saiki accepts notice on behalf of respondent number 6. Who's for 5?
5 for
can appear.
R for 6. He will appear.
Mr. R. Kaushik accepts notice on behalf of respondent number 5.
Oh.
This is a matter of the 4 weeks.
My lord.
In this matter, my lord, I have filed one IA, my lord, for modification of this order, my lord. And today, my lord, in this, they have filed.
Wait, let us see. Yes, who's for the writ petitioner?
I-
What is your case?
And my case is, my lord, I was the original appointed assistant
Huh?
teacher. I was
You
originally
were the
appointed-
assistant teacher.
Then thereafter, I was appointed as CRCC by order that.
So that is an additional charge, correct? Additional charge,
In charge. This is a,
additional work.
Yes.
Huh.
then my lord, in annexure to my petition, this is the order. Now, my lord, what happened in
Page,
page 14 of my petition?
page 14.
Yes, my lord.
Ah,
Serial number 2. release, CRC release, and against them I was Azia Rahman.
So you are.
Azia Rahman. Serial number two.
The following year released.
Newly engaged.
So you were newly engaged.
Newly.
Ah.
Then, my lord, what happened? Some people also kindly see, some one Gunotsov, one accident was taken place, my lord.
You are agreed with which order?
My lord. Answer 2. In the interest of public service and smooth functioning of SSA activities, and as per the proposal from BU Provincialization by letter so Kajigao, the following shares are have released from the concerned cluster.
Annexure 2, you are not agreed with Annexure 2.
Impugn order.
Huh?
Impugn order.
Hey, the impugned order is Annexure 2.
No, my lord.
Then where is the impugned order?
Page
Impugn order
21.
is 21.
Annexure 7.
Page 22. In the interest of public service, Ajay Rahman shares ICS syllabus cluster under Provincialization is hereby released from the position of shares and reverted back to his original place of posting as assistant teacher on Swansur LP school, single teacher with immediate effect.
So what is wrong with this order?
Because there is no wrong, but they should not be transferred or by giving blame me, my lord.
There's no blame. Where is that?
Blame is there.
Where?
You loss of kindly see blame. You loss of kindly see page 19. Some complaint has been lodged by the my teacher of my schools, who was the in-charge headmaster, and at head guidance, some SMC members has lodged in complaint. This is the complaint. Letter has been issued to me. Let the letter issued to me not a problem, and others complain not a problem. But instead of letter, they issued letter to all the teachers to take in view whatever my whether I have performed duty satisfactorily or not. Those person has been called, and those person made a statement, but that statement record has not been placed, my lord. And I come to learn that those teachers in favoring me, that I am past MSc in mathematics, my lord.
So you have been absent from school. You really attend school.
It is their allegations. It is their regulation that I have absent because cluster is sometimes we have went to for training course. I filed some documents, my additional affidavit, my lord. I filed documents that I in a month, most of the days were attached with the training program, my lord. Then, my lord, this is first type of allegations, my lord. He lost the vacancy again, page 20. Page 20, my lord.
Yes.
Yes. With reference to the subject item, you are hereby asked to attend for hearing office of the district elementary education of Swansur without fails as a complaint letter received from Ajana Khatur, SMC members and illegal others. On the basis of those complaints, my lord, I appeared. Hearing has been taken place, my lord. But record has not been furnished. What is the allegations? What is the complaint copy has not been served on me, my lord.
Yes.
Suddenly that
Who's appearing for the other side?
government.
Yes. Why was he taken out? Who is for the SSA?
I'm for a private matter. I felt I am not. So let them respond, my lord, then I will. In this matter, in fact, my lord, I felt I in this matter. So, my lord, and the headmaster, my lord, respond by 11. Altogether, enrollment of my school is 164, my lord. And neither the present petitioner is attending. My only respectful submission, my lord. Let him regularly attend the class as an assistant. He's already assistant teacher. Let him do the class. That is how.
I'm attending, my lord.
Mr. S. Bora is not here. What to do? Mr. S. Bora is not here.
Yes.
So any pleadings are complete?
Complete. They also SSA of the file.
Yes. Who is appearing for the SSA?
SSA file affidavit, my lord. That's number 3 and 4.
What is your case?
But though he's trying to connect with that notice, but here Malad, the issuing authorities are both are different. There is a complaint which is before the district elementary education, and this order is filed by the SSA, releasing him from the CRCC, which is
Correct.
additional charge.
Correct.
And that order itself Malad, clearly indicates what Malad, that he is a single teacher in that school. Yes.
He's a single teacher.
Yes, it. No, my lord, now there is a fourth teacher, he is not.
No,
in the
no,
class.
leaving that aside.
Yeah.
The
And
order.
I will attend the class, my lord. If my lord, they try to kill me, my lord. I made that is why.
You see, your main job is to teach. Your main job is not to do that cluster work.
Absolutely.
Your main job is to
Class-
teach. Why? So why should you be? Why should you be? How can you be
The
prejudiced?
cluster, they have the another job, my lord. Cluster resource are the person. They have the perform extra job, my lord.
Yes.
By the interim order, my lord will kindly see, is hereby released from the position of CRCC and reverted back to his original place.
Correct.
Yes.
What is
So
wrong?
he can't deny that I cannot go, I'll not go back. to the
Oh,
original.
correct. Yes.
And that, this order, nowhere there is no stigma in this order.
There's no stigma.
But letter is there. There issued letter.
No, no, that
By
is a
believing-
different thing. That
I
is
will
a.
also kindly see.
Yes, Mr. Who's for the SSA?
Let the SSA file evidence, my lord.
No, no. What is there to file?
SSA is basically on the party, it's a BTC, my lord.
SSA Kokrajar. SSA Kokrajar.
My lord,
You're not SSA.
I am.
You're SSA only
No,
for
BTC,
for huh?
BTC can appear, my lord, but my lord, difficulty is met. This matter is handled by Rita Boro, my lord, but she is unwell today, my lord. That's the difficulty. My lord. I don't have that file, my lord. Let it be fixed on Friday, my lord.
Everything we fix on Friday. Friday we have got too many.
Or tomorrow.
Next week, my lord.
Next week is motion day.
Motion day, my lord.
The very opening date of the vacation. This is my prayer.
After review vacation, in the meantime, there will some. I also submitted the application.
There is a stay order.
Yes, my lord, it's the order.
I also submitted an application before the authority to please transfer me from that school because they try to kill me, my lord. I give the
They try to
evidence.
kill you.
Yes, my lord. Paragraph page 44 is lost. Okay, see. Page 44 of that.
They will not try to kill you. You go back, do your job as teaching. That's all.
The case was registered, my lord. Case was registered. Headmaster was asked to keep a bond 10,000 to maintain peace of peace, my lord. Page 44, my lord. Philosophy, kindly see the moment. Headmaster, that respondent 11 was asked to give fund by the SDO, my lord.
Whether any affair complaint.
Yes,
or
FIR
certificate,
complaint,
yes.
not FIR case has been registered.
Okay, right.
Non FIR case has been registered, my lord. Those are.
Yeah, on the pressure parties, list the matter. On Saturday, 5th.
Yes.
On 5th.
Saturday, I will be not, my lord. Next, my lord.
Okay, list the matter on Monday. Give next week.
Yes, sir.
Just write one thing. The petitioner is aggrieved with the impugned order dated 28/10/2024, by which he has been released from his position of CROC in charge and reverted back to his original place of posting as assistant teacher. Bracket page 21. This is the matter on Monday. We'll dispose it of on Monday.
Into what has continue, my lord.
An attempt shall be made to dispose of the matter on Monday.
Into what has continue.
High interim order to continue till the next.
Okay.
May I please your lordship? Lordship, in this petition, the prayers are twofold. One is for release of arrear salary, and the second one is with regard to bringing the petitioner under the old pension rule. Now, regarding the old pension rules, lordship, there was a
Madam, you are a drop teacher.
excess teacher.
Lordship. Excess teacher, what right do you have?
Lordship, there has been a judgment regarding denial of the claim regarding excess teacher.
Let us see the judgment.
Lordship, that judgment has again been put to challenge before the division bench.
But
Now,
in that judgment, what is there? It says that excess teachers, you all are appointed in excess of the sanction post, correct?
lordship,
Then
they are
what
not
right do you have?
entitled, they are not entitled to pension in terms of the old pension rules of 1969. They are not entitled. The judgment says, lordship. Now
Then-
that judgment is put to challenge before the division bench. Lordship. That is under subject.
Then so what to do now? So it's a covered matter. Is there any stay of the judgment?
Lordship may take the matter after few weeks, Lordship. Let the order come from the division bench. Because the matter is.
Miss
Eight Talukdar, Lordship.
A. Talukdar, learned counsel for the petitioner submits that the present case is covered. Is covered by the judgment of a coordinate bench in WPC number.
Lordship, the read appeal has been preferred that I don't have the number, but
That Mohar Ali or what? No, not
Yes.
Mohar Ali, it's different. It's in the case of you get the number and you give it to him.
Lord,
In WPC so, comma, full stop, which is under challenge by way of WA number.
that I don't have.
That also you don't have.
Lordship, I have the WPC number, the
Then what is the WPC number?
WPC 6403 of 2021.
6403 of 2021. Party's name?
Purnima Hor and another.
Purnima Hore and another versus State of Assam and others. Right. She submits that though the said judgment is against the petitioner, the said judgment has been put to challenge before the division bench of this court, write WA number dash. Accordingly, release this matter after 3 weeks.
Much obliged.
You want your names there? Miss R.M. Barwa appears for
Referring to 188 of 23.
188 of 23. 188 of 23. Miss R.M. Barwa appears for the respondent number 2, while Miss N. Fukan appears for
For the eligibility department.
Respondent 1, 3 and 4 months.
1, 3, and 4.
Much obliged. Lordship.
May I please, Lordship?
Who's appearing for the other side? Date of birth.
Yes, Lordship. That has been duly verified and they obtained the necessary report from the Sheba also, which is there, Lordship, at page number 15 and.
What to do? There's no one here. For you, the adjournment is good.
Probably
27 is nearing.
not like that, Lordship. Because in the affidavit in opposition, they had not mentioned anything about the matriculation certificate. That has been duly verified and I am relying on that matriculation certificate itself.
Madam, after single. More of sign.
At two, Lordship,
Huh?
at two, if it is possible.
That too.
Item 16.
Is it infructuous or what?
Lordship, Lordship, some developments have, Lordship, for that, in that case, Lordship, I may be allowed some time to obtain the up-to-date instruction, Lordship, for my clients, Lordship. Where they have 51 numbers of petitioners, Lordship, 1 week time, or 2 weeks time, maybe granted.
In the meantime, I will also take the instruction. It's a matter of 2020 Lordship. And
Last
it
it was
got
listed.
listed after a long time.
Mr.
H. Mojumdar, Your Lordship.
H. Mazumdar, learned counsel for the petitioner, submits that prays that he may be allowed, he may be given time to obtain instructions. On the other hand, Mr. P. Nayak also prays for time to file affidavit in opposition. This is the matter after 3 weeks.
I will take instruction. Lots of many.
Obtain instructions and file affidavit if necessary.
Okay.
This is the matter after 3 weeks.
May I please, Lordship? Lordship, it's a pensionary matter. Petitioner is the first wife. His husband was died on 14/3/2017. My lord, but respondent number 8 is there. She is the second wife. She was married during substances of the first marriage. My lord, this petitioner earlier occasion, due to release of pension to the second wife, approached this honorable court. That order is at page 26, my lord. So, operative portion as last page 28, my lord.
Yes,
By that order, Honorable Court was pleased to dispose the petition by judgment at so and so, directing the Director of Pension to issue notice to the
So where is the director of pensions
my minute
order?
Director of Pension order is annexed to page 14.
Page 14.
Yes, my lord. As serial number 7, both the parties was directed, and second wife Dhanata Kalita was directed to pay.
Agrees to pay lump sum of rupees to
2,000.
Reena Kalita.
Yes, my lord.
Who is Reena Kalita? You?
Yes,
You're Reena Kalita.
yes, I am the first wife.
Says your second wife.
Second wife is Dhanata Kalita.
No,
my
it
lord.
says your second wife also.
Second wife is getting pension.
Second wife is getting. So she has.
After that, my lord,
So she has to give you. The second wife has to give you 2,000.
but my lord, some incident happened. According to my information, I don't have that death certificate copy. That second wife Dhanata Kalita was died. On
Danda Kalita has died.
that on 28, this certificate was given in Assamese language from Gaon Burha, but I don't have proper date because 28/8 or it is corrected to.
Look, Mr. Counsel, at the end of the day, there are two aspects.
My lord.
You're saying basically that the respondent
Hello.
is not paying you that 2,000 rupees which you are entitled to.
My lord.
Okay. If that is the case, you go to civil court. There's nothing to be decided here. That is a question of fact. We can only, you see, and whether this, we do not know about this agreement. This agreement has to be decided in the civil court.
My lord.
And then the
Um,
second issue,
My lord.
whether the second wife has died or not,
My lord.
that is a different issue.
My lord.
Once she has died, then you'll have to make your claim. I do not know. Or
My
what?
lord, then,
That is a separate thing.
my lord, my humble prayer is that if the second wife is died, then Director of Pension may, we will approach the Director of Pension.
We do not know. We do not know. You cannot come with half-baked
Yes, my lord, I
speculation.
don't have the death certificate, so I cannot.
You do not have anything. In fact, your first prayer also
My lord,
is what? Let us see your prayer. Your
Prayer
prayer is,
I have also mentioned the civil court issue, my lord.
huh?
My prayer was that respondent authority should not be directed to stop the monthly.
You see, there are many things out here. There is also agreement between you,
Legal
there's a Lok Adalat by
Yes.
which implies that you have been divorced,
My lord, yes.
in fact. Then,
The honorable court was prayed that till the civil court decides who is the legal heir.
so have you gone to the civil court?
I have not.
Then you go to the civil court. Because now you are asking, your prayer is to stop the monthly pension.
Yes, my lord. The honorable court already.
Till a
stopped, my lord.
competent civil court decides who is the legal heir of Prafulla Kalita.
Yes, my
Then you
lord.
go. Who is stopping you?
My lord, admittedly, this Dhanata Kalita is second wife, so honorable court has directed.
Mr. Counsel, you see, this is your prayer
My lord,
in this writ petition.
I admit, my lord.
That till a civil court decides, it should not be given. You go to the civil court and make the same prayer. That till you decide, please do not give pension. You cannot come here for an order and for an interim order and ask for a main order to be passed in the civil court. If the civil court, you have got to ask there first. Once it is not given, then you can go in appeal,
My lord,
but not by way of a writ petition.
my lord.
So what do you want to do? If you don't withdraw, then you know what's going to
My
happen.
lord, my lord. I will do it,
You can go to the civil court.
my lord.
Right. Mr.
Yes, Roy.
S.
Roy.
Roy, learned counsel for the petitioner, prays that he may be allowed to withdraw the writ petition and approach the appropriate forum.
My lord.
As his prayer in the writ petition is that a direction should be issued to the respondent authorities to stop the monthly family pension of the deceased Prafulla Kalita till a competent civil court decides who is the legal heir of Prafulla Kalita.
My lord.
Who appears for the other side? Mr. P. Saike appears for the pension department. Mr. B. D. Bhattacharya appears for the accountant general, Assam, or Mr. P. K. Bora appears for elementary education department. The prayer of Mr. So-and-so is allowed.
Interim order was there, my lord, to stop the pension.
The prayer of Mr. S. Roy Lerk also for the petition is allowed. This petition is accordingly dismissed as withdrawn, with liberty as prayed for. Full stop. However, in the interest of justice, the interim order dated 22/2/2021 shall continue to operate for a period of 1 month from today. That is still today's what date? Second, till first, till 1/5/2025.
Master lord.
That's all. This is only to enable you to go to the civil court.
Yeah, please, your lordship. Initially, the petitioner was appointed as midday meal cook, lordship.
Well,
Thereafter,
well, affidavit is ready, my lord. Day after tomorrow, I'll file my affidavit. my lord.
Affidavit is ready.
Affidavit is ready.
Item 19.
After I do it.
Okay, right. And the item 19, right? The issue here is as to whether the petitioner or the respondent number 8 is the cook,
9.
9 lordship.
or respondent number 9 is the cook. Full stop. Mr. S. Bora, learned counsel for the
Yes, yes, sir.
SA submits that the affidavit is ready and he will file the same within 3 days.
Tomorrow, I'll file it. my lord.
Within 3 days. List the matter after the week.
Legal lordship.
Yes.
Also, petitioners were all are the degree holder candidates. They,
Now, can we decide this without affidavit?
no, my lord.
So who is
They-
appearing
they
for the other side?
File everything.
Yes, who's appearing? Yes. So are you filing anything? Or is not required? Huh?
SSA is the main particular.
SSA is the main.
My lord.
Who is appearing for the SSA? They suddenly disappeared.
Yes, forum.
They were both here.
After some time.
Okay, next.
That will go. Well, the petitioner is the assistant teacher appointed in the year 1999. My lord, the policy decision review that not he who received the salaries up to 17/10/2006, they are entitled.
Where is the proof that you have received up to 2006?
My lord, proof is there, my lord. The petitioner received the salaries till September 2009, my lord.
Where is the proof?
I have this proof, my lord. Last page, please, my lord, annexure, my lord, 2, page 18-19.
18, 19?
My lord.
You said last page, this petition is still 52, 53. Yes, ma'am.
So my senior is on Nelson Port.
Okay, after some time. Or some time.
Petitioners, my lord, first case, my lord, item number 22, my lord. is the my lord petitioners are the my lord head teachers of the concerned ME school, my lord. And thereafter, my lord, as per 2017 Act, my lord, their service will provincialized as a tutor, my lord. And the petitioner schools, my lord, more than 4 teachers are provincialized, my lord. Therefore, my lord, it is, my lord, headmaster, my lord, and their, my lord, remuneration should be, my lord, as a head tutor, my lord, 12,000. But only, my lord, sanction, my lord, 10,000, my lord,
Actually, you don't have TET.
my lord.
Then what is wrong? What is wrong with the order?
And my lord, as per my lord, right to education, my lord, if the, my lord, more than 100 student, my lord, that is, there is a.
Mr. Council, you have got to have the educational qualification
My lord.
to get that pay scale.
My lord, the petitioner, the BA degree, man.
But you don't have TET.
State, my lord, don't have
Then
that, my lord.
TET is requirement.
My lord.
Then what is wrong?
And my lord, in my lord, full court, my lord,
Huh?
in full court, my lord, 2017 Act, my lord. In paragraph 179, stated, my lord, equal pay, my lord.
Equal pay, not equal pay. You cannot get equal pay. You can get at the best, you can get the minimum scale of pay,
My
not equal
My
pay.
lord.
You can, at the best you can get. That also provided you have the, if you are similarly placed.
my-
You're not similarly placed. You have got TET. You're not, I mean, you don't have TET. They have got TET. Then what's the case? You know, case.
my lord, as a head tutor, my lord, their salary, my lord, should be, my lord, 12,000, my lord, as a head tutor, my lord.
I don't know why. Why should you get 12,000 head tutor? How much are they? How much are the teachers getting?
My lord, 4 teachers was provincial.
Head teachers are getting how much? 12,000. You're a tutor. Why should you get 12,000?
My lord, at present, my lord, paid, my lord, only 10,000, my lord.
But unless you have
10,800.
TET, but where is your case? No case, Mr. Council. Where is your case? You tell me.
After a week, my lord, I will say
Huh?
this, my lord. After a week, my lord, fixed, my lord,
No. You tell me now.
my lord.
When the case is, when suddenly something goes against you, you want to adjourn.
No.
That's not. Where is your? You see, you have got you are required to have TET. You don't have TET. That's all.
But, till that, my lord, no to special date, my lord, rescheduled by the, my lord, government. Till that, my lord.
We'll tell them to schedule it. When were you made tutor? When were you made tutor? 21.
21, my lord.
21. So you have got 5 years time to
5 years, my lord.
5 years time.
About to
So
5
yes, you conduct a TET exam for them.
special, my lord, regarding the.
Yes, because I think in terms of yes.
If your lordship parents is pair, my lord.
Ah.
Pair is not that, my lord.
What is prayer?
Pair is, my lord. Page 21, my lord. Directing the respondent to state the petitioner as head teacher of the respective school, pay 21, my lord.
Yes.
Page 20, a rate of rate in the nature of mandamus should not be issued, directing the respondent to treat the petitioner as head teacher of the respective school, pay the salary as per the entitlement by relaxing the professional qualification of passing teacher eligibility test, my lord.
Relaxation can be done only by them. We cannot order.
My lord, now, my lord.
And then you have been
Most of the petitioners, my lord, the verge of retirement, my lord, about, my lord.
and the rules.
The rules, my lord, 2U, my lord.
Huh?
2U, my lord, is specifically mentioned, my lord. Tutor should not hold the post of, my lord, headmaster. 105, my lord, page.
Page
105.
this one. This one. 105.
5.
Yes,
105 U, my lord, second para, provided that a tutor shall not be eligible to hold the post of professor, principal, vice principal, headmaster, assistant headmaster, superintendent, assistant superintendent, as the case may be in additional institution provincialized under this act.
is head teacher and headmaster same?
Same thing.
Same, ma'am.
Then provisors here. You challenge these rules then.
No.
What do you want to do? You want to withdraw or dismiss?
My lord, another, my lord, prayer, my lord, I have stated in interim prayer, my lord.
The prayer is what?
My lord, to pay the 12,150, my
On
lord.
what basis?
My lord, because my lord, as per my lord, RTE Act.
You are not a
Higher
head
Education
teacher.
Act, my lord.
You are not a head teacher. If you see, to claim the same pay as a head teacher, you have got to be a head teacher
And
or
what-
equivalent to a head teacher, but you're not a head teacher. You're a
Yes.
tutor.
As per my lord,
And what-
17 Act, my lord.
Huh?
17
Tutor means teacher. It does not include a head teacher.
My lord, tutor may kindly see my lord schedule 127, my lord, page number.
Page 127. Yes.
There is a schedule, my lord, for remuneration, my lord.
127. Yes.
Schedule, my lord.
Yes.
Upper primary school, ME school, so headmaster,
Yes.
and fixed salary, my lord, 12,150.
Yes.
And my lord, in case of the my lord, petitioners, my lord, paid only my lord 10,800, but as a tutor, my lord.
Yes, madam.
Well, his service was regular, provincialized as tutor, my lord. That's why, my lord. He cannot claim more than that, my lord.
The tutors, where is the tutor's pay? Is it here? In the-
10,000, my lord.
10,000, my lord.
Huh?
Kindly see my lord, assistant teacher, my lord. Assistant teacher, below my lord, headmaster.
Below
10,800.
headmaster at page?
Page 127, my lord.
Assistant teacher, yes. 10,800.
800, my lord.
So you're getting that.
My lord, but not getting my lord 12,150, my lord. Because my lord, in ME school, there is no provision of headmaster. In case of my lord, if the enrollment is below than my lord 100, my lord. But petitioner schools, my lord, is above the 100, my lord, and
But you're getting the same pay as a teacher. What is wrong? You're getting same pay as Hindi teacher, Arabic language, assistant teacher. What is wrong?
my lord, 1,800.
You're a graduate teacher.
Graduate teacher, my lord.
You're a graduate teacher.
Graduate, my lord. Headmaster, my lord, of the contract.
No, you cannot be headmaster because of the proviso.
But my lord, provincialized as tutor, my lord. But initially, my lord, they were my lord headmaster, my lord.
My lord, initially they were headmaster because of the qualification, my lord, they do not have, my lord. That's why their service has been provincialized as tutor, my lord. Because, my lord, it is specifically mentioned in page number 105, my lord. You, my lord, tutor means and includes the assistant teacher, teachers, classical teachers, also included lecturer, assistant professor, professor, assistant headmaster, superintendent, assistant superintendent in provincial education institutions under this act, who are not eligible for provincialization of their services, whose services cannot be provincialized in the post of teacher under this act due to lack of his educational and professional qualification, my lord. The petitioner do not have that qualification, that's why his service was provincialized as tutor, my lord.
Tutor includes assistant teachers. It is here. So you're getting 10,800. What is wrong?
My lord, as per my lord, right to education act,
Huh?
my lord, right to education act, my lord. The my lord, ME school, there is a my lord headmaster, my lord. If the enrollment is above the 100, my lord. And if the enrollment is my lord, below than 100, my lord, then my lord, she is eligible for provincialization, my lord. There is no post of headmaster, my lord. But in case of the petitioners, my lord, their enrollment is above the 100.
So how does it matter?
For assistant teachers provincialized, my lord, in their school, my lord. For assistant teachers was provincial, including the petitioners, my lord. And
So
as
you're
per
getting,
RTA Act, my lord,
so you're getting 10,800. So what is wrong?
It ought to have been 12,000,
No,
150
no.
schedule specifically it mentioned headmaster and their remuneration schedule 127.
But you are not a headmaster.
In Fantastic, we are headmaster.
At venture is a different thing. Venture is a different. You go and join a venture. You leave this school. You leave this provincialized school, go to a venture school and join there.
Subsequently, provincial as a tutor,
Nothing. No case.
But at least the remuneration part as a headmaster,
No, not at
both
all.
officers were provincialized, and
No,
RT Act,
no case.
there is a provision for headmaster,
There is no reason for you to get that. Any citations in your favor?
No. But I have categorically stated, in case of compassionate appointment, there is a relaxation, for TET, and in case of the petitioner, there is over 50, above 50, there should be a relaxation regarding TET,
You have not challenged your appointment order also. Then you have not challenged your appointment order. Then if you have challenged a portion of your appointment order, then we could consider, but you have not challenged. What remains?
And here, 18 petitioners are there, there cannot be
First.
same cause of action like that.
18 petitions.
18
petitioner, is a headmaster of different school. 18
They are headmasters of different venture schools,
venture school. Subsequently,
subsequently provincialized
provincial as a assistant or as a tutor,
as a,
tutor,
and all of them were provincialized as tutors.
provincial.
And who is the head teacher of your school?
Subsequently, they were adjusted to base school, There is no,
Okay, thereafter there was a amalgamation of schools. And they were teaching earlier in a what school? Primary school, upper primary,
ME school,
ME school, and they were amalgamated with a
Maybe high school or high secondary or
high school or a higher secondary
as
school.
per 6 scheme,
Then that way, so you could not become headmaster because you are the base school will become headmaster. And then you do, and to be a headmaster of a provincialized school, what is the requirement? You have to have TET. Is it? As per what? As per 2017 rules. Oh, is it? So then you do not have TET. Then, but you have been given the option, I think, in your
I have except
in your appointment order, you have been given the option, correct? Where is your where is the order? 21.
And it starts from 71, 76. This series.
Where is that portion requiring him to? Oh, he has only. Okay. You have only annexed. You have not annexed all the conditions. Condition number 6 is there. Condition number 6.
Next page, page 77.
So condition number 6.
Any tutor who has already required the qualification required as per NCT guidelines and service rules in force on the date of issue of his appointment shall be entitled pay and allowance within a period of 5 years.
The provided what is there, provided that the tutor who acquired such qualification within 5 years.
So you have got to acquire.
I have my lot education qualification, I have got my lot already my lot. But in so far as my lot TET concern my lot, no drive, special drive has been my lot.
No, what is the special drive? You go and apply, take a course and say, and TET, I think must be, they must be conducting TET exams every year, or what? Who conducts TET exams? Who conducts TET exams?
SSA, my lord.
SSA.
SSA.
You go. I heard
Till date,
Mr.
they have not approached the, till date, they have not approached the concerned authority also, my lord.
SSA is a party here.
No.
Oh, SSA is not a party. Heard Mr. K.R. Patgiri, learned counsel for the petitioners. Also heard Miss S. Tutia for
Respondent number 1, 3, 6, 7, and 8,
1, 3, 6, 7, 8,
8, 9, and 10 also.
9, 10 also. Mr. I is I Alam for
Respondent number 4 MCP.
respond number 4. Ms. R. M. Barwa for respond 2. And Mr. P. Saikia for respond 5. What's up? Next para. Right. The petitioners were the petitioner's grievance is that though their services have been provincialized as tutors under the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act, 2017, hereinafter referred to as the 2017 Act, the petitioners have not been paid the salary of head teachers of the higher
My lord,
of the high school slash higher secondary schools.
my lord.
Further, the further grievance of the petition, the petitions have also prayed that the requirement of having the qualification of passing teacher eligibility test (TET) should be relaxed in case of the petitioner's hearing. Next para. The petitioner's counsel submits that the petitioners were, just tell me the facts, if I'm wrong. The petitioners were the headmasters of various venture schools, which were subsequently provincialized. Venture ME schools,
ME school.
which were subsequently provincialized under the 2011 Act,
17 Act.
2017 Act. Full stop. The schools of the petitioners were thereafter amalgamated with higher schools slash higher secondary schools, wherein in terms of the policy and the 2017 rules, the head master slash teacher of the base school, that is the high school slash higher secondary schools, were appointed as the headmasters of the said schools. Next paragraph. The the petitioner's counsel submits that Petitioners council submits that the petitioners who were earlier head teachers of various upper primary schools should be given the salary given to head teachers / headmasters, that is rupees 12,150 per month instead of 10,800 per month. He also submits that the requirement of having TET qualification for upgradation of their pay of their salary as head teachers is nigh impossible, NIGH, nigh impossible for the petitioners inasmuch as they have crossed 50 years of age. Next para. Miss S. Kutia, Learned Counsel for the Elementary Education Department, on the other hand, submits that in terms of the proviso, no, submit that in terms of section 2, bracket U, a tutor means and includes teachers, assistant teachers, etc. Headmaster is also included, madam.
Well,
Tutor means,
headmaster, assistant headmaster, superintendent, assistant superintendent.
ah, no, so if your tutor can be a headmaster also.
Well, they are included, but next
Huh?
year, madam, provided that the 8 tutors shall not be eligible to hold the post of professor, principal, vice principal, and headmaster, madam. Next para, madam. They are
Okay,
included,
in a provincialized.
madam.
Tutor means and includes teachers, assistant teachers, classical teachers, headmasters. No, but it says in a provincialized education institution.
And
Please
under
read.
this act, madam, they are included, madam, but next line, madam, who are not eligible for provincialization of their service, whose services cannot be provincialized in their
Acha.
state post.
Wait. Tutor means and includes teachers, and also, who are not eligible. Okay.
Due to lack of our educational and professional qualifications.
Haha. Tutor means and includes teachers, assistant teachers, classical teachers, uh, lecturers, headmasters, etc., who are not eligible for in a provincialized education institution under the 2017 Act, who are not eligible for provincialization of their services in the post of teacher due to lack of educational and professional qualifications required as per the Right of Children to Free and Compulsory Education Act 2009, National Council for Teachers Education Act 1993, University Grants Commission Act 1956, and other relevant rules and regulations framed thereunder, and any other act, as the case may be. She also submits that the proviso to section 2U provides that a tutor shall not be eligible to hold the post of professors, principal, vice principal, headmaster, assistant headmaster, etc., as the case may be, in an educational institution provincialized under this act. Where does it say that TET is required for headmaster?
It is prescribed under the matter, NCT Act, NCT Act.
Where is that page?
2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009. 2009.
Under the NCT Act. He also submits that in terms of which section? Huh? Huh?
2014 regulation.
In terms of which regulation?
National Council for Teacher Education, determination of minimum qualification and
Which? I said which number? 1, 2, 3, 4, 5. Which one?
Last malot 6 to 8 malot.
She also submits that in terms of
B malot.
the
Pass in the necessary.
what is this regulation called? Huh? I think we'll take it up at 2. Find out.
Well, that is their National Council for Teacher Education notification.
Yes. We are concerned with classes
6 to 8 malot.
6 to 8.
Paragraph number, page number 6 malot. Roman 2. Classes 6 to 8
Pass. You need pass. Set pass.
malot. And malot, last malot, and. Past in the.
No, but then you have been amalgamated with the higher school, no? With the high school.
But I have to teach malot upper.
And
primary
the upper
school.
primary.
Malot.
Okay, right. The Miss S. Chutia further submits that in exercise of the powers conferred by Section 23, bracket 1 of the Right of Children to Free and Compulsory Act 2009, and in pursuance to the notification number SO full stop 750 bracket E dated 31/3/2010, issued by the Department of School Education and Literacy, Ministry of Human Resource Development, Government of India, the National Council for Teacher Education, bracket NCTE, has laid down the minimum qualification for a person to be eligible for appointment as a teacher from class 1 to class 8, wherein
Malot.
the teacher eligibility test, bracket TET, is to be obtained by the teacher in question. He submits that the set TET qualification has not been obtained by the petitioner, and in terms of condition number 6 of the order dated 5/2/2021, by which the petitioners have been appointed as tutors, they have been given 5 years' time to obtain the said TET qualification. She submits that As the orders dated 5/2/2021 have not been put to challenge, the petitioners would have to obtain the said qualification. That's all. Nothing else, no? Accordingly submits that the writ petition should be dismissed as there is no merit in the writ petition. Dismiss, full stop, that's all. I have heard the learned causes for the parties. Full stop. Next paragraph. As can be seen from the submissions made by the council for the parties and the pleadings, comma, the petitioners are seeking a direction to be issued to the respondents to treat them as head teachers of their respective schools by being given the pay / salary given to head teachers. The further prayer is for a direction to the respondent authorities to relax the qualification of passing test. Full stop. Next paragraph. As can be seen from section 2(u) and the proviso therein, and section 2(u) of the 2017 Act. No, not the 2017 Act.
79.
2017 Act. A tutor cannot be a tutor is not eligible to hold the post of headmaster or head teacher in an educational institution provincialized under the 2017 Act, comma, if he does not have the TET qualification. Full stop. Next paragraph. In the present case, there is no challenge to the rules, especially section 2(u) and the proviso therein. Full stop. The above being said, where is the pay given? Pay of the,
Please 127 men.
the above being said, 127.
Fixed salary admissible to a tutor, madam. Heading, madam.
Huh?
Petition 76, my lord. Yes, 76.
Page 76.
1,800.
Their provincialization order, madam, page 76.
No, the pay of the assistant teachers and head teachers. And
That is in the act, madam, page 127. madam.
127.
127. Further, the schedule to section 8(3) of the 2017 Act has fixed the salary admissible to a tutor in cases like the petitioner. Where does it say? To be,
Primary school, my lord. Upper primary school.
to be equivalent to an upper primary school. No. Assistant teacher of a upper primary school. That is 1080. 10800 for the first and second year. And thereafter to 12,000 for the third to fifth year. The headmasters, on the other hand, start from a fixed salary of 12,150 to 13,500. As the petitioners cannot be made headmaster as they do not have the TET qualification, which headmaster requires to have, this court does not find any merit in the claim of the petitioners for paying for being paid the salary paid to a headmaster. Next paragraph. With regard to the petitioner's claim prayer that the qualification of TET should be relaxed in the case of the petitioners, this court finds that the NCT has already fixed the TET qualification as a TET qualification as an eligibility criteria for a teacher teaching in class 1 to 8. So the same is also not under challenge. Further, the appointment orders of the petitioners dated 5/2/2021 provides that tutors who do not have the qualification of TET as per NCT guidelines and service rules on the date of issue of the appointment order as tutor, the tutor shall acquire such qualification within 5 years from the date of issue of his or her appointment order, and thereafter be entitled to the pay and allowances equivalent to teachers with effect from the date of acquiring such qualification. The said condition in the appointment orders dated 5/2/2021 has also not been put to challenge by the petitioners. Correct? In view of the above reasons, this court does not find any ground to exercise its discretion in the present case. The writ petitions is accordingly dismissed. Common order meaning what? How many writ petitions? There are 2 writ petitions. Different purposes. Common order. Information.
Time being item 2.
Really, I was under impression that it was notice was issued, the law 2021 matter, my lord. My lord, basically my case is that my lord, respondent number 7 is junior to me. And in spite of that, my lord, my name is also forwarded, my lord, depriving me. He was junior.
The respondent number?
7.
Okay, yes. No, the government was not there. Whether provincialization of the petitioner done or not?
But if notice has not been issued, my lord.
No, but I think this matter has been listed earlier, that's why. And
also under the
you
impression
were supposed to place instructions. But of course, that was around 2 years back.
So let's,
So we'll issue notice.
my lord, you will notice an returnable, my lord.
Right, Mr. T.J. Mahanta, learned senior counsel, submits that while the service of the respondent number 7, who is junior to the petitioner, has been provincialized under the 2017 Act, the petitioner's service has not been provincialized till date. Issue notice returnable in 4 weeks. Ms. S. Tute accepts notice on behalf of
1 to 5, my lord.
1 to 5. That's all.
6 and 7 is also there.
Who are 6 and 7?
Headmaster and the other.
I'll take it.
Okay, petitioner will take steps for service of notice upon the respondent 6 and 7 by a registered post with AD within 3 days. List the matter after 4 weeks.
Timing item 7.
Item 7.
Yeah, please, Lordship. Lordship, the Guwahati University actually given the letter or power from the Assam Provincialized College and Assam Non-Government College Management Rules 2001. But this Dr. Sarvapalli Radhakrishnan B.Ed College does not come under this rule because grant in aid and ad hoc grants in aid must be received by the private college. So in this case, actually, we have not found any specific guidelines of NCT. So NCT maybe clarify that position. Actually, who is the proper authority to appoint the principal? Because first appointment was given by Project Samata. That's
Huh?
first appointment of the principal.
So how many principals have been there in the college? One.
Only one. So in this case, NCT.
Who is for the NCT? Yes, you clarify who is in a private unaided college. Who can appoint the principal? Whether it is
Before that, we request the lordship to come to case
whether it is the
60.
management committee or whether it is the sponsoring body.
Kindly come to.
Huh? Governing body. Yes.
In fact, it is there in the, my lord, NCT. Page 60 also, my lord. Kindly come to page 60, my lord.
Page 60?
60, my lord. Of
Where-
the
Audit petition.
My lord, this is the terms and condition of service, my lord. Page 60, my lord. This
Yes.
covers, my lord, appointment of the all teaching as well as non-teaching staff, my lord. Here, my lord, can you come? Basic terms and conditions of service, welfare 5, number clause A, my lord. The appointment of these positions shall be made on the basis of recommendation of the selection committee constituted as per the policy of the UGC or affiliating university. That is, in this case, my lord, affiliating university is government, Guwahati University. My lord, Guwahati University has already clarified their stand, my lord. I have already clarified before lordship, my lord. Again, my lord, your lordship come to page 64, my lord.
Yes.
64, my lord. Here is the provision of managing committee, my lord. That is governing body. Kindly, may I read, my lord. The institution shall have a managing committee constituted as per rules if any of the affiliating university concern state government. In the absence of such rules, the institution shall constitute the managing committee on its own. The committee shall comprise representative of the sponsoring body, man. And trust educationalist and teachers.
Ah.
My lord,
So managing committee, yes.
sponsoring body we have already there.
Yes, yes.
Hello, everything is under the governing body, my lord. Nothing is with the sponsoring body. They have only nominated only 4%, my lord. That is not mandatory also, my lord.
But then you cannot you have to appoint someone. You're the managing
I
body.
have already
You are the
published-
managing body.
Yes, governing body, my lord.
So
already
but
published.
you'll have to appoint somebody else, not the president.
Definitely, my lord. And moreover, my lord, may I please, my lord. Moreover, the government, GB has adopted and resolution 22/3/2025.
Page?
My lord, I have not annexed, my lord. I have informed, my lord. The GB had already adopted resolution, my lord, to appoint some other person, my lord.
Okay.
The next senior most, already resolution, my lord. Only with the pendency of the case, my lord, they are silent, my lord.
No.
Whatever rule says, my lord, I cannot.
Correct.
Party rule.
Correct. Heard?
It is already there, there. We have already tried everything, my lord. Only due to the illegal intervention of the, without institute part of the DXC, my lord.
Correct. See, you're only on that only.
Yes, yes,
You're
my lord.
challenging that
Yes,
only.
yes.
Heard Mr. S. Hawk, learned counsel for the petitioner. Also heard Mr. S. Roy, learned counsel for the respondent number 7. Mr. P.J. Fukan appears for respondent number 3 bracket Guwahati University. Comma, Mr. B. Dury appears for respondent number 5, while Mr. I love for respondent number 2. I love for respondent number 2 bracket NCT. Next, right. The petitioner is aggrieved by the just a minute, where is it?
Yes, 57.
Where is the impugned order? By the impugned, is aggrieved by the impugned order dated 10/3/2025, issued by the District Commissioner Nalbari, by which the Inspector of Schools, Nalbari District Circle, has been directed to take charge of,
Take over that.
take over the charge of principal of which college?
Principal temporarily of Dr. Sarvapalli Radhakrishnan, Teachers Training and Research Institute.
Of Dr. Sarvepalli Radhakrishnan Teachers Training and Research Institute, Tamata, Nalbari, hereinafter referred to as the institute. Proceed. The petitioner's counsel submits that the institute, being a unaided private institution, the district commissioner has got no competence or authority to direct the inspector of schools to take charge of the post of principal. That's all. This is what I do? Okay, then. Next. Mr. S. Roy, the learned counsel for the respondent number 7, which is the sponsoring body. Sponsoring body?
Yes, Madam.
Sponsoring body of the institute, submits that as the institute is an unaided private institute, the institute has the authority, the final say. No, the sponsoring body has the final say in deciding who is to be appointed as principal, and they do not have any issue with the inspector of schools taking over the charge of principal, as the petitioner's candidate, that is the earlier principal, was what? Was what?
6 years old person at present.
Was 66 years old. Besides what? Being what? Misappropriate, corrupt, what?
Nothing.
Nothing.
Some charges are there, but I cannot say he is a corrupt person. Charges are there.
Besides there being corruption charges against the candidate of the petitioner.
No, that is, he is not a candidate.
But he is present principal, which was ousted by the DC's order to appoint the inspector of school. So present principal is still,
That is not.
he is holding the post. Actually, he is on leave. He is not.
So why are you against the this thing, the managing committee,
Because
governing body or whatever?
there is allegations are there before the DC also. Lots of crores of monies are
That's what I'm saying. Corruption. That's what I'm saying.
mismanaged.
No, I mean, okay. Due to the earlier principle being due to the earlier being the candidate of the petitioner who was involved in mismanagement of the institute. Correct.
My lord.
Who was having allegations of mismanagement of the institute made against him. Full stop. Next paragraph. The Mr. Mr. P.J. Fugan, learned counsel for the Gauhati University.
Yes.
So he has given this letter. Is it?
27.
Where is that? Where is the letter? Your Guwahati University letter.
We have, sir. Strictly technical.
So, so this is correct, according to you.
Correct.
Submits that the appointment of the principal of a private BEd college affiliated to Guwahati University is based on an interview for which a panel of experts is submitted is constituted, it should be
Is constituted.
constituted by the governing body of the college. He submits that the sponsoring body, he submits that neither the sponsoring body nor the district commissioner has the authority to appoint a principal
Milo.
of a private college.
Accept that document.
Private unaided college. Next, Mr. I. Alam, the learned counsel for the NCT, submits that the sponsoring body and the sponsoring body of the college and the district commissioner do not have any authority, do not have any competence to appoint a principal, do not have any competence to appoint a in charge principal of a unaided private college. Full stop. That's all. Mr. Bioderi, what do you say? You say that he has the competence.
No,
No, no,
second circumstance, we were bound to interpret it. Now, by the as per the rule.
okay. Mr. B. Diori, the learned counsel for the district commissioner, submits that. Submits what?
After the facts and circumstances as attention were drawn with regard to this law and order situations at program. So under that circumstance, I
Submits that the only reason the district commissioner had directed the inspector of schools to hold a charge of principal of the institute was due to apprehensions of law and order problem. Correct?
and interventions were sought from them.
Further intervention in the school administration having been sought for by the sponsoring body of the institute, that is the respondent number 7, comma. The district commissioner had intervened only at the request of the respondent number 7. That's all.
Yes.
I have heard the learned counsel for the parties. Full stop. The fact that the institute is a private unaided institute is not disputed by any of the parties. The only question that has to be decided is as to whether the petitioner, who is the governing body of the institute, is the authority who is to appoint the principal of the institute, or whether the district commissioner and the sponsoring and the respondent number 7 have the competence to appoint a principal of the institute. Full stop. Regulation 5A, regulation 4 bracket Roman 5 capital, bracket Roman A, no, bracket A small of the National Council for Teacher Education, bracket recognition norms and procedure, bracket close, regulations 2009, page 56. Hereinafter referred to as the 2009 regulations provides that provides for the appointment of the faculty and the principal on
Page 60 will be appropriate, my lord. Page
faculty
64,
and the,
five.
huh?
Page 64. Page 64, 5. Regulation 4.
That's what I was saying, page 60. That's what I'm reading. Provides that appointments, appointments to the sir, shall be made on the basis of the recommendations of the selection committee constituted as per the policy of the UGC / the affiliating university / the affiliating body. Full stop. In the present case, the institute has been affiliated with the Guwahati University. And the Guwahati University has submitted, and the academic registrar of the Guwahati University has issued a certificate dated 27/3/2025, which states that the principal of a private B.Ed college affiliated to the Guwahati University is appointed by the president of the governing body of the college. Full stop. And is based on an interview for which a panel of experts is constituted by the governing body and approved by the Guwahati University. Full stop. Next paragraph. The certificate dated 27/3/2025 issued by the academic registrar, Guwahati University, is made a part of the record and marked as Annexure X. Next para. Next para. Regulation 7 bracket B of the 2009 regulations provides that the institution shall have a managing committee constituted as per the rules, if any, of the affiliating university concerned. Affiliating university. Full stop. In the absence of such rules, the institution shall constitute the managing committee on its own. Full stop. The committee shall comprise of representatives of the sponsoring society / trust, educationists and teacher educators, representatives of the affiliating university and of the staff. Full stop. Next paragraph. A reading of the above clause, regulation 7 bracket B clearly shows that the sponsoring body can only be a constituent of the governing body, and it cannot have an identity of its own to manage the administration of a private college. Full stop. In view of the next paragraph, the above being said, the further question that arises as to whether before that, thus Annexure X and the 2009 regulations clearly show that it is only the governing body of a college that will have the final say in the appointment of a principal of an unaided private college. Full stop. Next paragraph. The above being said, the question that still needs to be answered is whether the district commissioner had the competence to appoint the inspector of schools to take charge of the post of principal of the said institution. Full stop. In this respect, it would be profitable to refer to the decision of the apex court in the case of Union of India versus Tulsi Ram Patel, reported in 1985, 3 SCC. 398, wherein it has held that a source of power must exist for its exercise. In the present case, the respondent number 7, the respondents have not been able to show. No, the respondent state government and the respondent number 7 have not been able to show the source of power under which the district commissioner Nalbari had empowered the inspector of schools to take charge of the post of principal of the institute. Full stop. As such, in the absence of any rules being shown, the action of the district commissioner by the impugned order dated
10/3/2024.
10?
10/3/2024.
10/3/2025 is not sustainable in law. Accordingly, the same is set aside. Full stop. In view of the reasons stated above, the petitioners are to the petitioners who is the governing body of the institute shall appoint a principal. Full stop. Shall appoint the principal as per the policy of the affiliating university. As per the policy of the UGC/affiliating university. Full stop. Further, as regulation 4 bracket Roman 2 bracket Roman 1 small. No, don't say that. Say further in terms of note 2, regulation 4 bracket 1, no, bracket 2, Roman 2 bracket Roman 1, page 58 of the 2009 regulations, the petitioners should ensure that no person who is beyond 65 years can be appointed as a principal of the institute, even on an in-charge basis. That's all. Yeah.
My lord, here, this. Continue with the advance.
I've already said that. Why should I mention? Okay, as the petitioners have already published an advertisement dated.
It is at page 69, my lord.
Advertisement dated, no date.
Yes, advance dated 12/3/2025.
Huh?
12/3/2025. Paragraph 12, man. I have stated.
12/3/25.
Yes.
Where is that? Where is that?
I have stated page 14, my lord, paragraph 12.
Page 14.
Yes, my lord. Paragraph 12, my lord.
Okay, 12/3/25. For appointment of a principal of the institute, comma. The respondents, the petitioner shall ensure that the same
Yes.
is appointed at the earliest.
The consequential order, my lord, page 73, that.
Huh?
Page 73, my lord. That taking over the charge of the fee.
I've already set it aside.
Yes, my lord.
I've already set it aside.
Otherwise, my lord, principal will also insert, IS will also inflict on that, my lord.
Huh?
IS will also give interest on that, my lord. That this order had not been challenged, my lord. That is.
I have already set it aside earlier. You have not heard it. Around 2-3 paragraphs earlier, I have set it aside.
The lordship, I have heard that this is order, my lord.
Huh? Acha, this order is what?
This is the taking over the charge by the IS, my lord.
Arey, when the first initial order has been issued, then there's doesn't
Oh, my lord.
this goes.
My lord.
Time frame of completing the appointment of principal.
Till then, my lord, I will make alternative arrangement from the, I have already stated. Till then, my lord, next, I have already, GB have already taken resolution, my lord. Till then, till the regular,
Till regular, then who will continue?
senior most, my lord.
Okay. Within a period shall complete the, what have I said? And not later than 3 weeks from today. No, cannot be. You have to, cannot be, you have to invite,
Then what will happen?
within 6 weeks from today. 6 weeks from today. In the meantime, the senior most teacher
Right.
of the institute may be appointed as the in-charge principal
I'm obliged.
by the petitioner.
Obliged.
The request is accordingly disposed of. Okay, wait, in the.
Time being item 50.
You ready, madam? You are ready?
We have filed our affidavit. Nothing will be taken any other day
Huh? Some other day.
on Friday. Otherwise, I'm ready.
He's ready.
Is up to you, lord.
What do you have? What have you said in your affidavit?
Yes, fine. Yeah, madam. Directly come to page 29.
29, yes.
Our affidavit. Para 4.
Yes.
That the petitioner has referred the present writ petition praying for setting aside the impugned order dated 15/5/2018, whereby the petitioner was directed to retire from service with effect from 31/7/2018 with a future further prayer to allow the petitioner to continue in service till the date of attaining the age of superannuation on the basis of his date of birth, 1/12/1967. While disputing the claim of the petitioner, the deponent humbly begs to state that the deponent ought to have retired from service on 31/7/2018 on attaining the age of superannuation, since his date of birth as recorded in the service book at the time of joining in the service is 31/7/1968.
Okay, wait. Okay, madam. Now, what is your date of birth?
Lordship, in the service book, it has been mentioned as 1/12/1967. And as per the 31/7/1958, Lordship.
Huh?
31/7, 31st of July, 1958.
31/7,
7, 1958.
1958. That is in your service book.
Exactly, Lordship.
And
And the HSLC certificate, it is 1/12/1967, Lordship.
HSLC is
1/12/1967.
11267.
Is annexure one lordship in the main petition. Page number 12.
When did you join service?
That was in the year 1976 lordship.
1976.
Yes, lordship.
You joined as what?
As office peon lordship.
As office peon?
Yes.
Which date?
On 15/11/1976 lordship.
15/11/1976.
Now they have verified the particular certificate. It is there in page number 15 lordship annexure 4 from Sheba. The lordship kindly see that particular page 15 lordship annexure 4. With reference to your letter cited above, I am to inform you that as per this office letter number such and such, dated such and such, dated such and such, verification report in respect of Arun Chandra Shrikia bearing roll number such and such of HLC has been sent. As per your request, the educational documents of the candidate are again verified with office records and found as shown below. So they have verified all the papers, lordship. That was their charge.
Now you tell me one thing.
Lordship.
According to you, you are born in 1967.
Yes, lordship.
If you joined service in 1976, how old would you be?
9 years.
9 years.
No, that issue, lordship, that issue has been taken care of by the judgment of this honorable court. I'm just referring to that judgment, lordship. In that particular matter, this honorable court has taken note of that thing, that at the very initial age, because at that point of time, the office boy, he was engaged as an office boy. And this honorable court has observed, if your lordship kindly see this particular judgment.
And you're counting your period of service from 1976.
No, lordship, I'm saying about after completion of 18 years, lordship.
Okay.
If your lordship kindly see this particular judgment, there's a second paragraph,
Yes.
this second page.
Yes.
There's the fourth paragraph, lordship, starting from after.
There.
After hearing learned counsel for the parties on perusal of the materials on record, what transpires is that as per the date of birth of the petitioner, in terms of the matriculation certificate, he would retire from service on superannuation on such and such date, which is just a couple of days away. No doubt, entry of the petitioner into service as a grade 4 employee on 26/11/1963 was irregular in the sense that he did not attain the minimum age required for entry into government service, which it stated is 18 years. However, it is to be noted that the matriculation certificate of the petitioner has not been challenged or questioned by anybody. Ordinarily, in matters relating to determination of the age of a government employee, matriculation certificate is the most important document, since as per matriculation certificate, petitioner date of birth is on 1/6/1/57. His date of entry into regular government service may be treated as on completion of 18 years of service. That is on 1/2/1975. The service rendered by the petitioner prior to 1/2/1975, that is 26/11/1966 to such and such, may not be considered as regular service for the purpose of competition of pension.
Okay, tell me in here.
Even in this case also, lordship, he entered into service at the age of 9 years. So that was
Maybe, but you entered as office peon.
office peon.
Yeah,
That
how
was
can
a
you enter office peon
That was
class
a-
at age 9?
That was not a regular service, lordship. It's an office boy, and since the matriculation certificate has not been put to challenge, and this matriculation certificate, they have verified it on various occasions. And pursuant to that verification, lordship, I'm saying that this date of birth is to be taken into account, lordship. And whatever the service rendered by the petitioner from his date of entry till he attains the date of maturity, 18 years, that should not be counted. Because this matriculation certificate is the paramount consideration for ascertaining the date of birth. And that has been verified by the
Date
respondent
of birth
authority also.
1967. When did you do your class 10 examination? Let us see your matriculation certificate.
Yes, lordship, annexure 1, lordship. 86, lordship.
Huh?
86.
1986.
After taking due permission from the
Date of birth is 1/12/67.
67.
Being successful, I certify that Arun Chandra Shaikia, roll number, full. Mm,
86. 56.
You see this annexure 1,
Yes.
admit card. Shri Arun Chandra Saikia, son of so and so Saikia, roll number D56. Madam, have you seen?
Madam?
Please look. You have not seen. Please look at page 12 of the writ petition. Roll number D56. Have you got? Admit card
Yes, madam.
D56. Now come to page 13. Roll number G55.
No, both have been verified, Lordship.
Huh?
Both have been verified. If your Lordship kindly see annexure 4, because he failed on that particular exam, then compartmental.
Annexure 4.
Annexure 4, page number 15. Both the roll numbers have been verified. It's D56 and G55, both are there. He appeared
Is
in the
is Seba a party here? I think we have to
there-
call for
No
Seba.
party here, madam.
We'll make Seba a party here.
They have verified
Find
this particular.
No, we'll verify it again. How
Yes.
to verify it again?
Make them a party.
We'll verify it again because you said annexure 4, correct?
Yes.
Okay, right. The petitioner's case is that his date of birth has been wrongly entered in the service book as 31/7/1958. So so in your service book it is 58. So what is wrong?
No, this is to be corrected as
It
67.
has been corrected.
Corrected to be as 67, Lordship.
It was corrected by the state government
No. That was originally 31/7/1958. So he submitted an application
for correction.
for correction. That
Was it
not-
corrected?
That was not done. That's why they approached the state court law.
And you're continuing because of that.
Yes, Lord.
How can you?
Because there is an order of this honorable court, Lordship.
There was a
Honorable
stay
court
order
passed an
passed.
order, stay order passed.
Wait, this is going to delay everything if we issue notice. If we make them parties. Let me see.
Which one?
Where is your appointment order?
That I have not attached, Lordship.
Oh, you have not annexed.
Yes, Lordship.
Very conveniently.
Not conveniently, Lordship. The issue was only with regard to the correction of date of birth.
No.
Authorities.
When you have joined at when you're age 9 years old, it is very convenient.
Yes.
Because service book I have attached.
You must have been very tall for a 9-year-old with mustache and everything, I think.
That is the assessment of the authorities who had allowed me to join, Lordship.
I think you should go to civil court to prove your case. Make Seba a party out.
And subsequently, Lordship, if your Lordship kindly see page number 24. Page number 24.
Just a minute.
And page number 20 also.
When did you ask for change of date of birth?
If your Lordship kindly see the annexure 2.
Annexure two is
Annexure 3, sorry, Annexure 3, Lordship. That is the communication made by the elementary education officer to the Commissioner Secretary of the Government of Assam. Page number 14, Lordship. With reference to the subject cited by the honor.
this is their letter. I'm asking about your letter.
No, the communication from the authority I have attached, Lordship.
What about your
here it
letter?
is
I want to know
specifically
your
mentioned.
letter.
Here it is specifically mentioned that Arun Chandra Saikia
Huh?
They have not.
regarding correction of date of birth as per
No,
agency certificate.
no,
Accordingly, it has been corrected in the
no,
service book. That is what I am referring to the page number 20 and 24.
Submitted by the petitioner.
Pursuant to that communication, the date of birth has been corrected in the service book. 20 and 24, Lordship.
Change. By And why is it that your son has signed the affidavit, not you?
Where, Lordship?
You read petition. I, Rajdeep Saikia, son of Arun Chandra Saikia, age about 27 years.
Well, at that point of time, probably he was suffering from some illness, Lordship. He was admitted to
Where is the pleadings that you are suffering from some illness?
that I have to ascertain, Lordship, because.
No, nothing to ascertain. We cannot go beyond what is here.
No, since he has been authorized, it has been mentioned, I have been authorized by the writ petitioner to swear this affidavit, Lordship.
So let us see how he knows everything.
Lordship.
How does he know that his father was working as a chai wala or whatever, chottu as in a canteen or something? I don't know.
No, the annexure, all these annexures are showing the actual aspect of the matter, Lordship. Now, the fact is that since in the service book, it has been corrected. If your Lordship kindly see page number 20 and 24, the date of birth of the petitioner has been corrected pursuant to the certificate, because that has been duly verified by the authority concerned. And accordingly, it has been corrected. Now, even after correction of the date of birth, Lordship, that order has been issued, which has been put to challenge before this honorable court on 10/5/2018.
Has joined in this service as personal peon with scale of pay as the deputy inspector of schools. Page 18. According to transferred to the office of the inspector of school Charadio, while letter dated 83. So in 83 you were 16 years old and still transferred and joined in Charadio. Promoted in 87. In 87 you were 20 years and you were promoted and joined. And almost 42 years. So he has been serving since 1976. And now it's 19, now it's 25. Next year is going to be 26. So that means he's been serving for how many years? 60 years? 50 years? 49 years. I think there should be direction for recovery of salary also. And this come from the government employee, almost 42 years of yes. So if he from 67, if he works till 27, no, some 76 to 27, 27 years plus 24 years will be 51 years. So he'll have worked for 51 years.
No, if we go by this 67, then he will attain the age 18 years on 85, Lordship.
Huh?
85.
85?
85. He will be 18 years on 1985. So we'll be going by.
No, if you are born in 1967, 60 years from 1967 will be 27. That is what. And you joined in 76. 76 to 2000 is 24 years. And 24 years plus 27 years means 51 years. So congratulations, you have worked. Now you return the money also.
You have to return, there are several judgments of the whole.
Yeah, that is whatever you do. You can
The
do
service
whatever.
book has been corrected. Lordship, the issue is with regard to that order which has been passed. Because
Well,
annexure
well, well,
seven, I'm
just-
challenging
just-
annexure seven.
Yes, yes.
Now,
Good.
how they have verified and because the verification is very much, verification is there. They have verified from the Sheba and from that particular verification.
I do not know how Seba has done it,
Exactly,
but one
Since
thing
it
I
is
know
not
is
under
that you are not at, you are at fault also.
Since it is not under challenge, so how they have corrected and how they are.
You cannot
they have
take,
issued the impugned order.
you and Seba have wrongly done it, that's all.
That is to be verified, Lordship.
No, no.
This is.
You
the
verified.
respondent authority is saying like that, this is absolutely based on speculation. Because
Right.
there is no concrete document
Okay,
with
right,
regard to that.
I've heard. Heard, Mr.
SP Chaudhary, Lordship.
SP Chowdhury, learned counsel for the petitioner. Also heard Miss N. Fukan, learned counsel for the elementary education department. Anybody else? No. The grievance of the petitioner is that the date of birth of the petitioner has been wrongly entered in his service book as 31/7/1958. The next paragraph. The petitioner's case is that he was born on 1/12/1967 and he was appointed as an office peon. Where? In which office?
So, under respond number 4, Lordship.
Appointed as an office peon
Karai do.
in the office of the respondent number 4 on 15/11/1976. Next paragraph. During his service period, he was transferred to the office of the Deputy Inspector of Schools, Charadio, White order dated 4/10/1983. Full stop. During his service period, the petitioner appeared in the high school leaving certificate examination held in the year 1986, and he passed the same along with the compartmental examination. The petitioner's counsel, next paragraph, the petitioner's counsel submits that as per his HSLC admit card and HSLC certificate, the petitioner's date of birth has been recorded as 1/12/1967. Next para. The petitioner was also promoted to the post of lower division assistant by order dated 1/8/97, and he was again promoted to the post of senior assistant by order dated 8/2/2008. And he is presently working in the office of the Deputy Inspector of Schools, Charadia. Next paragraph. The petitioner's counsel submits that due to the wrong recording of his date of birth in his service book, as is clearly proved from the HSLC admit card and certificate, he requested the concerned authority to correct his date of birth in his service book from 31/7/1958 to 1/12/1967. Full The authorities have thereafter communicated with each other with regard to the prayer of the petitioner for correction of his date of birth. However, the same has not been done till date.
The date of birth has been corrected in the service book, Lordship. Which is
Has
page
been
number,
seven. Okay.
page number 20 and 24, Lordship.
Where?
Page number 20,
Page number 20.
in 2018, it has been corrected.
Where?
Page number 20, if your Lordship kindly see the column in the right hand side, as per certificate issued by the Sheva certificate number such and such, his date of birth is fixed on date dated 1/12.
Yeah, he submits, what have I said? He submits that thereafter the petitioner's date of birth was corrected in his service book on 29/5/2018. No, was corrected to 1/12/1967 on 29/5/2018. I do not know why the respondent authorities also, why you not bringing the records? All his no appointment order of his is here. He is hiding everything. And why you not bringing it? He is hiding each and every order. It's very clear that this is a clear case of, I do not know, this service book also, it may be fabricated.
Yes.
Well, how is this entry here? From where did you get this copy of the service book? From where did you get it? It's in your possession.
No, it is not my.
Your son will know it. Your son is the person who says.
The thing
Let
is,
him explain. I think your son should give an affidavit.
it is on record, Lordship.
I'm going to keep this parted anyway.
It's on record.
What have I said? Next para. He also submits that the Board of Secondary Education submitted a verification report dated 29/4/2017, where it has been reflected that the date of birth of the petitioner is 1/12/1967. The petitioner's counsel thus prays that the petitioner should be allowed to remain in service till his age of superannuation, that is 1/12/1967, and to set aside the impugned order dated 15/5/2018, by which the petitioner had been asked to retire on 31/7/2018. So stop. Next, Ms. N. Fukan, the learned counsel for the Elementary Education Department, submits that the petitioner ought to have retired from service on 31/7/2018 on attaining the age of superannuation, since his date of birth as recorded in the service book at the time of his joining in service was 31/7/1958. As such, the claim of the petitioner to remain in service after 31/7/2018 is not tenable. Full stop. She also submits that the petitioner had misled the government by influencing the Deputy Inspector of Schools Charadir, due to which the petitioner's date of birth had been wrongly changed from 1/2/1967, no, from 1/31/7/1958 to 1/12/1967. She submits that the petitioner's date of birth had been changed due to the letter dated 29/4/2017 issued by the Secretary Board of Secondary Education, Assam, where his date of birth had been mentioned as 1/12/1967. He submits that it later came to the notice of the government that the date of birth of the petitioner was 1/12/1967. No, it came to the notice of the government that if the date of birth of the petitioner was considered as 1/12/1967, then the petitioner had joined government service at the age of 9 years, since he joined his service on 15/11/1976, which is not possible as per the government rules. As such, White Office Order dated 10/7/2019, the instruction dated 10/5/2018 to correct the date of birth of the petitioner was cancelled. The instruction dated, accordingly, while letter dated 10/7/19, direction was issued to the Director of Elementary Education, Assam, to treat the date of birth of the petitioner as recorded at the time of his joining as recorded in his service book at the time of his joining. Next para. The DEO Shivsagar thereafter issued an order dated 15/5/2018 requiring the petitioner to retire from service on it attaining the age of superannuation on 31/7/2018. Observing that the petitioner had been serving as a government employee for almost 42 years. Next para. I have heard the learned counsels for the parties. The petitioner's date of birth, as recorded in his service book at the time of his joining, was 31/7/1958. And in terms of the said date of birth, the petitioner should have retired on 31/7/2018. The petitioner has, however, taken a stand that his date of birth in the HSLC admit card and certificate. It is also a stated fact that the petitioner had joined government service on 15/11/1976. in terms of no, if we are to assume that the petitioner's correct date of birth is 1/12/1967, comma, then the petitioner would have served the government would have to serve the government till 31 no, till 30/11/2027, comma, that is for 51 years. In which case, he would have been a private citizen without any government job for only 9 years of his 60 years. 9 years at the time of his superannuation at 60 years. This is clearly an attempt by the petitioner to take undue advantage of the government. First off, it is impossible for a boy of 9 years to be appointed into government service. And even if we are to assume that he was appointed into government service at 9 years, comma, he cannot be allowed to. No, cut that portion. Huh? Next. It is the case of the petitioner that he was appointed into government service at 9 years. Interestingly, the petitioner has not annexed any of his appointment orders in the writ petition. Though the government documents show that the petitioner had joined his service as a personal peon on 15/11/96 with the scale of pay of rupees 190-2-200-3-242-4-250 per month in the office of the Deputy Inspector of Schools, Nalbari. Full stop. He was accordingly transferred to the office of the Deputy Inspector of Schools, Charadio, while Assam, letter number EAA.17/83/25209 dated 4/10/1983 and joined his service at the office of the Deputy Inspector of Schools, Sonari, Charadio on 10/10/1983. On 10/10/1983, the petitioner would only have been 16 years of age. The petitioner was thereafter promoted to the post of LD assistant and joined as a LD assistant at the office of the Deputy Inspector of Schools, Charadio on 1/8/87. It is interesting to note that on 1/8/1987, the petitioner would have been only 21, would not even have been, would have been 20 years of age. Would have been 20 years of age only. The petitioner was again promoted to the post of senior assistant at the office of the Block Elementary Education Officer, Sape Khati, Vice Lakhi Pukan, by letter dated 8/2/2008, and he was transferred from the office of the BEO Sape Khati to office of the Deputy Inspector of School Charadio on 5/7/2008. None of the above documents have been annexed by the writ petitioner. The affidavit that has been filed, that has been submitted along with the writ petition, has been executed by the petitioner's son, one Rajdeep Saikia, who states that he is fully acquainted with the facts and circumstances of the case, and that the statements made are true to his knowledge, and the rest are matters of record. So, sir. The fact that the service particulars of the petition, no, the service particulars of the petitioner, as stated above, have been recorded in the letter dated 18/5/2018, issued by the District Elementary Education Officer, SIPSAT. That is 15/5, 15/5. Yes, said 15/5. 15/5, huh? Page 18. Next paragraph. On considering the fact that the petition had been appointed as a personal peon on 15/11/1976 on a pay scale of rupees 190-2-200-3-242/4/250 per month in the office of the Deputy Inspector of Schools, Kawan Albari. It is very clear that the petitioner could not have been 9 years of age at that particular time. As such, this court is of the view that the present case appears to be a fabricated case on the basis of the HSLC admit card and certificate, which is annexed to the writ petition. Interestingly, the Board of Secondary Education has not been made a party in this writ petition to ascertain the veracity of the HSLC admit card and certificate. This court is accordingly of the view that when it is clear that the petitioner has been appointed to government service on 15/11/1976 on a pay scale, on the regular scale of pay, comma, there was no question of the petitioner being 9 years of age at that time. In fact, the petitioner would most probably have been only class, what?
Class 5. Class 3.
No, further. No, say in fact. Further, the admit card, the HSLC admit card and certificate shows that the petitioner had allegedly passed his class matriculation only in 1986. Full stop. In which case, the petitioner would most probably have been in class 1 or 2 in the year 1960s, in the year 1976, when the petitioner was appointed to government service. Naturally, he was 86, he finished his matriculation, but he joined in 76. So 11 years passed. So he must be in nursery or something like that, or KG or something. When he was probably in nursery or KG, just like that. Just like that. Huh? No, there was no nursery that time, just right? KG or class 1. KG or class 1. Okay, just say, hearing concluded, judgment reserved. I'll just make it smoother.
So take note of the judgment.
I'm not, you do whatever. I'll see.
Deeply.
Right.
21.
But you should have been more alert. Madam, you should have been more alert. Because of a stay order, he is continuing for so long. 25 now, 7 years. This is a misrepresentation. Misrepresentation. Maybe a fraud is involved also, I don't know. Because how can it be? If he was 9 years old in government service, taking a pay scale, how can he go to school? And finish his matriculation in 86, 87, 11 years later. What was the qualification for that post? Grade 4, maybe class 8 that time? Class 8. So please bring the law of 1976. 1976, what was for a grade 4 post, what was the law? What was the eligibility criteria? Yes,
Lordship here,
item?
item 21.
Yes.
Lordship here, I have sent the affidavit for getting. Lordship may take it up next week. Lordship.
Okay, Mr. B. Chaudhary submits that the affidavit in the position to be filed by the respondent number 5 and 6 has been sent for vetting, and the same will be filed within a week.
Yes.
List the matter when? After vacation.
Date, my lord.
After vacation.
Time being 22.
May please, Lord. My lord, the annexure 2, my lord, the last page slip. 99 appointment, Lordship, 2009 termination, 2015 reinstatement, no salary was paid. He's claiming salary from 2015 to remaining period, till today, Lord. In the period of termination. 15 reinstatement.
Restatement when?
Termination in the year 2009, madam.
No, you're claiming money paid from when? Which period?
2000
2009 to 2015.
onwards, madam. 2009 to.
But did you work?
Madam, that is another aspect, Lordship. And this entire series is going on in 6020-2017 lead case, Lordship.
Okay.
Partnered matter, Lordship.
Okay, 6020.
So this matter
Will-
may,
Oh, no, if it's already partnered,
yes.
okay. So we'll put it there.
Madam, matter, madam,
We'll put it there,
madam, just.
partnered matter. You're right. Mr. P. Nayak, Learned Standing Council BTC submits that similar matters are being partnered in court number,
Court number 17, Lord.
court number 17,
And the lead case is WPC 6020.
comma, the lead case being WPC,
6020-2017.
okay. He accordingly submits that the matter may be tagged along with WPC so-and-so. Huh? List this, tag this matter along with so-and-so, huh? And list it along with Miss L. Gogoi appears on behalf of Mr. Sri Barwal and counsel for the response number 6. 6020 of 2017.
1825.
25.
That's for last order, Lordship. The petition has submitted non-real certificate before the DDO, Lordship.
And in this case, my DO has submitted the proposal matter, but there is some discrepancies matter. That's why director has directed the DO to submit fresh proposal matter.
What is always happening? DDO will submit.
DDO has already submitted matter, but there is a discrepancies in the date matter. He
Ah.
should written he has written matter February 2013 matter. It should be February 2014 matter. Therefore, my director has directed the DO to submit fresh proposal.
DO. Write what letter? Dated?
Dated matter 1st April 2021.
Miss S. Rutia, Learned Counsel for the Elementary Education Department submits that as there was a discrepancy, comma, the director has issued a letter dated 1/4/25 to the
DO Dhubri
DO Dhubri
and the block BO Dhubri, South Salmara.
for resubmission of the same after correcting the mistakes in the earlier proposal. List the matter on, give a date after vacation. Wait.
Yes, date number 6, Lordship.
Unless
Item 27.
My lord, petitioner was appointed.
Who's for the other side? So according to them, you are not in the DIAS data prior to 2000, no, till 2011-12, you are not in the DIAS data. Correct.
Yes, it is their statement, but my lord, in the affidavit, not a single document is annexed from where they have found this.
And you have got documents in your support of your case.
Yes, my lord, my appointment letter is there from 2003 to, and one document, my lord, your lordship will find page number 20, my lord.
20.
20.
Yes.
20 document is a challan in the 2011 Act. It is a document of 8/12/2011. I was the headmaster I was appointed in 2003, and 2008, I was appointed assistant teacher. And 2010, being the headmaster, I had applied for provincialization in under 2011 Act. This challan, as a headmaster, I
But
have,
where is your DIS data
my lord,
prior to 2011?
my lord, in my application, my lord, of the 17 under 17 Act, page number 21 onwards, my lord. Page number 21, the third clause, I have mentioned, my lord, 9, 10 dice, code number so and so. In my 2017 application under the new.
What is your DIS data number? This one, code number is
Yes, yes,
5417.
yes, this is the number.
Is SSA a party here?
My lord.
SSA. Who can confirm this DIS data?
Accessible. So see, now my lord, he says that, my lord, we have not given any document.
Huh?
He said that we have not given any document.
Yes.
When the DIS data does not contain his name, my lord, there cannot be any document because that NUPA DIS. My lord, the
So
DIS
where is the DIS data? Can't it be downloaded?
My lord, kindly.
No, you see, when there is a data available, can it be, can't you download your that DIS data?
The DIS data that can be downloaded. Now the DIS data which is maintained by the NUPA, my lord, the definition of DIS under the 2017 Act is the DIS which is prepared by the SSA and maintained by the NUPA, National University of Planning Administration, Delhi.
Where is that?
Kindly find the page 103. My lord. Smaller.
103.
103, page 103.
Yes.
The definition of DICE code. DICE code means District Information System for Education Code, prepared by the SSA, Assam, and as available in the records of the National University of Educational Planning and Administration, New Delhi. So initially, my lord, under the 2011 Act, we used to refer to the DICE data.
So this issue, whether they have the DIS data prior to 2011, 2012, can be decided by SSA.
SSA.
Yes.
My lord, kindly, my lord, for a moment, page number 52, my lord. Page number 52, their affidavit, my lord, paragraph 3, my lord.
52.
52, my lord.
Yes.
Paragraph 3 is the reply of my whole writ petition, my lord. May I read, my lord?
Yes.
Only paragraph 3, my lord. That instead of giving each and every paragraph reply of the writ petition, your opponent herein begs to state that the original file from where the matter for provincialization of service of petition number so and so.
Correct. It is missing.
It is not correct, my lord.
No. We can't help it. We cannot say it is not correct or not correct.
Because
you see, we have got to accept it as correct.
Yes.
Now, once we accept it as correct, what is the next logical thing to do? To reconstruct. If it can, now how do you reconstruct? One way of doing it is we ask to do a shortcut method is to ask the SSA to bring the DIS data of your school for that particular, that's all.
My lord, whatever.
Why are you scared of the SSA bringing the DIS data?
No, not scared of, my lord.
Then they will clarify everything.
My lord, whatever.
End of the matter.
Whatever mentioned in paragraph 3, my lord. In the my lord next page, my lord. It is the matter of records mentioned, my lord. So, my lord, but not a single document is annexed, my lord. Several documents.
So that is why to clarify the issue.
Yes.
SSA is required. Once SSA says yes, here's the data. End of the matter. If there is no data, end of the matter. That's all. They are the judge.
My lord, my simple prayer is that, my lord, whatever, my lord, in paragraph 3, my lord, they mentioned as records, my lord, that may be, my lord, brought to record, my lord. That is my humble submission, my lord.
It is already in the record. We will see. Let the SSA produce the show. What do? We have to make them a party or what?
Yes. So, my lord, I may be allowed, my lord, without filing any application, my lord, if allowed, my lord, I can. It will be
Okay, right. Heard Mr.
MJ Kadri.
Learned counsel for the petitioner and Mr. B. Kaushik for
All the respondent except my lord 4.
all the respondents except respondent number 4. The petitioner's case is that the respondent's case is that the service of the petitioner could not be provincialized as there was no dies data in respect of the petitioner till 2011-2012. Further, it is the case of the respondents that the original file regarding the provincialization of the service of the petition has gone missing and they are unable to trace the sick. On considering the fact that the Dias code is being maintained by the Sarba Siksha Abhijan bracket SSA and placed in the records of the NUEPA, New Delhi, comma. And in terms of section 2 bracket I of the 2017 Act, the SSA, the Sarva Siksha Abhijan, represented by
The mission coordinator.
by the mission coordinator, comma, address,
Kahilipara, my lord, Guwahati.
Kailipara, Guwahati,
Guwahati.
should be implemented as respondent number. Respondent number 6.
I'm sorry, my lord, it should be mission
That's
director.
7. Mission director.
Mission director.
Mission director, not coordinator. Respondent
Coordinator
number
is
7. The SSA represented by the mission director, Kahili Para Guwahati, is accordingly implemented as respondent number 7. 7.
Yes.
The petitioner shall submit an amended cause list,
Cause title.
cause title to the registry within 3 days. Who appears for the SSA? Mr. B. Gogoi accepts notice. Issue notice to the respondent number 7. Petitioner accepts notice. Mr. B. Gogoi accepts notice on behalf of respondent number 7. Mr. M.J. Khalid shall provide extra copies of the writ petition to Mr. B. Gogoi during the course of the day. Next para. Mr. B. Gogoi shall obtain instructions as to whether the petitioner's name is found in the Dias data pertaining to 2009-10 and other years. List the matter. After vacation, give it, when? April, May.
I will have to place the dice data, madam.
That's all. That's all. Send me.
Public.
Only my one copy name is.
I said extra copies.
I'll have.
28 and 29.
No one appears for the petitioners on call. List the matter after vacation. You have not filed any affidavit.
No, my lord, because the petitioner on the last day, my lord, he will have to seek instruction and whether he want to apply under the scheme or not. I was supposed to have the instruction by what time we can, my lord, complete the
Decide.
process. Yes.
May I please your lordship? Yes, on last question, I was directed of the instruction. My lord, I had discussion we are unable to comply with the framework. And we are not in a position to apply either for alloy or NOC. The reason, my lord, permit me to cite two conditions in the framework which could not be pointed out on the last occasion. My lord, at page 29 of their framework, there are two. Page number 29 of my requisition.
Yes, para two.
Land. To open a nursing pharmacy allied health science institute in Assam, the applicant must ideally own the required land as per direction of the respective council in the name of the institute itself and should have permanent patta or possession.
No, it says ideally.
Ideally.
Ideally means that that's what
Patta
they
land.
preferred, but
Preferred.
it doesn't mean that it has to be owned. It can be rented also.
Yes, my lord. If the land is rented, then there is a cap provided, given, or if the land is leased land, the lease should be for minimum 70 to 90 years with the first option to buy. So it is stringent. Furthermore, my lord may come to para 4. Technical hospital. At present, I have tie up with Nemcare Hospital and Get Hospital where my trainees, they go and they have their training for 2 or 3 days. Now in the framework, for allied health science 4B, for allied health science pharmacy institutes, the institute applying for opening new allied health science pharmacy institute must have a 100-bedded technical hospital, teaching hospital with X-ray clinic, with radiology, ultrasound, CT scan facilities, and NABL accredited lab. That is National Accreditation Board for Testing and Calibration of Laboratory. Or if I do not have 100-bedded hospital, or cushioning has been provided, that is, the institute should have MOU with a government hospital not below the level of district headquarters hospital for a specific period of not less than 5 years. The number of institutes to be tied up with the government hospital will be regulated as per 4D. So, my lord, I cannot make false assurance. I cannot run the, I cannot apply. It perhaps government realize that how much time will be taken for one applicant to comply with this regulation. That's why government has answered. Their answer is 3, para 3 of page 29.
Yes.
The requirement of building is clearly laid down by the respective council as regard to the size and other requirement units. After the applicant has applied for EOI and obtained an NOC from the government, the required infrastructure should be ready in all aspects by 2-3 years. 2-3 years. So, my lord, I was agitated. We were assailing the order of the deputy commissioner, which he passed on 4/7/2024, which is at page 32. Page 32. In the framework, there is no mention of deputy commissioner. No role assigned to the deputy commissioner. Deputy commissioner did not issue me a show cause. He did not call me for any explanation. He passed an ex parte order, directed his joint director to go and seal my institute. He came, he pasted a notice, he closed my institute. My lord, I am paying house rent, I am paying teacher salary, everything is in disarray. Now, I plead that since I am unable to come under this framework, so I will withdraw. And Deputy Commissioner Respondent 5, he may be directed to open my institute so that I can hand over the rented building to its lawful owner, to the owner. I can take away my property, furniture, and if necessary, I will submit one NOC undertaking to the Deputy Commissioner that when in the event of opening, I will not conduct any course there.
Which course?
This the courses which I was running, laboratory technician and OT technician.
That can be, otherwise if he is withdrawing, then we have nothing to say, because Lordship will see, from the pleadings, Lordship will see it's not an institute who has taken the affiliation and concurrence from the competent authority. It's a branch of one institute in Jaipur or Raipur. Now, how can an institute, open a branch here and he will start giving certificates, of a diploma? That's why probably, this everything exercise has been done, that framework has been, made out so that, this can be regulated. Mushroom growth, in the state.
Where is the impugn order?
Page 32 of my retribution.
Okay, so all the things that are all the certificate courses that you are imparting, which has anything to do with this framework, will be stopped by you. Correct?
My lord, I have not come under this framework idea.
No, but then you see, all the courses
Oh.
that have been mentioned in that regulatory framework that you have been imparting, that is going to be stopped by you.
I will not undertake.
That's why that will be stopped by you. And then in that case, then the building can be opened and he can do whatever he likes with the building.
Yes. That part,
Okay, my lord, respondent 5, Deputy Commissioner, he can be directed to open my building.
Correct. So we'll just pass a short order.
That's it.
Mr. B.S. Sharma appears for the petitioner, while Mr. B. Goy, Leonard Additional AG, Assam, appears for the state respondent.
Yes, 1 to 5.
No, 5 by me.
Huh? Okay.
1 to 5.
Huh?
1 to 5.
Yes.
What, Mr. Deary? You are for 6. Okay. Okay. The petitioner's case is that the petitioner's case is that the MS Institute of Public Health and Research Balipara has been sealed by the deputy commissioner, by the district commissioner, Sonitpur, on the ground that the courses being run by the petitioner came within the regulatory framework of the nursing, pharmacy and allied health science sectors in the state of Assam. Inverted commas close. Regulatory framework from regulator. As provided in the notification dated 7/11/2023 issued by the Medical Education and Research Department, government of Assam. What have I said? Just read. Full stop. He submits, the petitioner's counsel submit that on instructions, he would like to withdraw the case with an undertaking that the petitioner will not conduct any course which comes within the regulatory framework said so. However, the District Commissioner Sonitpur should deseal the institute and allow the petitioner to make use of the property in some other manner. Next para. Mr. B. Gogoi, the learned additional AG, submits that the courses being run by the petitioner in the said institute comes within the regulatory framework says so. And as such, the institute was required to be affiliated with the Srimanta Shankara Deva University of Health Sciences. Stop. He, however, submits that in view of the undertaking, in view of the submission made by the counsel for the petitioner, that the institute would not run any course within the run any course which is provided for under the regulatory framework censor. He does not have any objection to the prayer made by the petitioner's counsel. Next paragraph. In view of the consent of the parties, the district commissioner is directed to deseal the institute being run by the petitioner. The petitioner is consequently directed not to run any course within the institute that comes within the regulatory framework as provided in the notification dated 7/11/2023. That's all. The writ petition is accordingly disposed of. I is in view of the orders disposed of accordingly.
As directed by your lordships, my lord, we have filed our affidavit yesterday, my lord. So since they are protected by the last order of your lordships, my lord, wherein your lordship was pleased to pass an order that admission will be subject to the outcome, lordship, and take up the matter after the vacation for hearing, my lord, admission hearing. Or I leave it to your lordship. I am ready today itself. My lord.
They don't want to, they want you out.
They want to oust me, my lord. That's true. But at the same time, my lord, on the last occasion, our lordship was pleased to protect their interests also by passing an order that my admission will be subject to the outcome. If I fail, my lord, then the parents of the petitioner number 2, they will.
But then you say next day, supposing your repetition.
I'm only, my lord, concerned about one aspect, subject to, my lord, what your lordship finally considers. I'm only, my lord, concerned about there maybe the subject matter may be different. In the other petition, there is an order by this honorable court allowing her to continue. I am not worried whatever will be the outcome of this petition. It may get dismissed or it may get allowed, my lord. Possibility of allowing is much because there is gross violation of natural justice. But even then, my lord, I am a little bit skeptical on that point that there is a running interim order which is similar to the order passed by your lordship on the first day. So that's why if that decision comes in the meantime, because it's
What has happened to that decision, that case?
Not,
Ah.
that is reserved for judgment.
reserved for CAB, my lord. It was
Well, By which court?
by
Court
court number
number?
23.
Chaudhary,
No.
You can.
you can add. Let us wait.
My lord, we have already taken step for that case also, my lord. So, my lord, kindly.
They filed an IA in that case,
Yes, my lord.
seeking leave of the honorable court
Yes,
in
my
that particular case, but that IA has not been listed or
Seeking leave for what?
because there is an
Because
interim
it's interim
order.
my lord. That is another sector, my lord.
Allowing-
That is
No, let me
regarding the
finish.
compulsory terms
Hello.
of the parents, my lord.
No. Subject matter is different. There is no
Different.
doubt about it. But there is an interim order saying that the daughter will continue with her studies in the school until further order. That is a specific order passed by the court, my lord. So that's why, I leave it to your lordship, but I feel, my lord, same order is there in that writ petition. They have filed an IA also, but they haven't listed it. They made no endeavor to get the IA listed. But they have
I'll
only asked
take
for
steps on that case also, my lord. First, my lord, dispose on disciplinary ground. Then only, my lord, I am going, I have already taken the steps, my lord, in that case also. My lord.
I am ready. It depends upon you two only.
Ready, my lord. If he is also ready, then.
No, I can start, no problem, my lord. I'll just start it. Reply কোন আছে না? হ্যাঁ? মলয়, reply কোন?
My lord.
No. No, I don't know. Wait, huh? Yesterday?
Yes, my lord. Yesterday we.
Yesterday. Opposition. Affidavit in opposition. What is it? There are two affidavit in opposition.
Yes, my lord. I have filed one small affidavit, then they told that that is too small, my lord. That is
That
not,
reply affidavit is not here. In the record.
my lord. Actually, another case is also pending. That is disciplinary matter since 2020, my lord. That is happening. That's why, my lord, I am in hurry.
They will.
My lord,
Acha,
this is
same thing.
the issue is not practice different, my lord, disciplinary matter, my lord. And that is difficult for the school to take any step, my lord. That is the difficult for Sonic school, my lord.
My lord, the school is in a habit.
23,
My lord, the
from
school is in a.
2023, that is.
My lord, the school is in a into a practice of, for no reason, withdrawing the student from the
Cannot
school.
say,
One
my lord,
second, my lord.
without, my lord,
No,
going
there
into
is
the merit of the
My
case,
lord,
my
there
lord.
is a covered judgment of this honorable court wherein exactly on similar situation, the students were withdrawn without giving any show cause notice, without holding any inquiry, without any material. This honorable court has said you cannot do such thing with the
No,
student.
that has not been given till now, my lord. Order that is on, that is reserved for judgment, that case only. But that is
Perhaps my-
2022 matter, my lord. So, my lord, that is happening in the Sonic school. My lord, Sonic school cannot take any action against that, and indiscipline action is going on day by day, my lord. That is the difficulty, my lord. Otherwise, I don't have any hurry, my lord. That is the difficulty for the school authority, my lord. That is a Sonic school, my lord.
How long will you take?
I have already filed my affidavit application. I don't take much time, my lord. Faster than me. So it's up to your lordship. That is our
Definitely.
difficulty is that, my lord. I have to
Let's
say,
fix it after the view.
because once they take the disciplinary action
Because
against
the evidence, the affidavit is not here.
yes, ma'am, I know that. That is up to your lordship, my lord.
Ah.
But our difficulty is that.
I know. Only problem is, you see, I've got some practical difficulties also. You see, now the cases that we take up, we pass orders here. Some are complete, some are not complete. we've got to correct, we've got to fine tune. Takes time.
Yes, that
Because now I will have to sit alone after you all go have your chai in the chai wala next door. We too will be sitting here correcting. That takes time. That takes time. So I don't know if you
yes, that is now
Time,
for
time.
15 years. But our part, I'm just apprising our
I know,
part.
I know, I know.
Because once with the Sonic School take the decision, this action on disciplinary method, they come before the court and case is pending.
Look, I've got no problem disposing of. Huh? I mean, I don't mind. Only sometimes it becomes difficult.
15 and that is not in.
I've got a meeting also at 4:30.
Yes,
Yes. Yesterday we had a meeting till 8,
Really,
6 to 8.
it's a tough,
And I have to go and study
yes, it's a tough thing,
for today.
obviously.
Time permit and honorable court allowment, funds can be taken for next week, my lord, if
No,
possible.
they are already protected.
But that is not protected, my lord. We cannot take any decision. That is we become precedent for the Sonic School now, my lord.
My lord,
Okay,
any school, they will do anything, my lord. Is it the thing? My friend is repeatedly saying, we are Sainik school, we are Sainik school.
Okay, we'll take it up next Tuesday. Then let's.
Tuesday, some difficulty, lordship will take up after the vacation, my lord.
I don't
Lordship
think
says,
difficulty, but
one second,
I
my lord,
want,
lordship says kept the thing subject to the outcome.
that is.
My
my lord.
admission is subject to the outcome, and that was the specific prayer made by my friend on the last occasion. She agreed to it. Then now, my lord,
When are you free? Wednesday?
lordship will take up immediately after the vacation for disposal. Next week is the motion day for all said and done. On Tuesday, my lord, I'll be out of station on 8th of my lord, this month, my lord. I'll come, my lord, 9th midnight. I'll reach.
9 midnight.
Yes.
What about the after?
Last week also same thing happened, my lord. I reached midnight 12 a.m. my lord. My friend fixed the matter on the next day, my lord. Last week same thing happened. That may not be repeated, my lord. Lordship will take up immediately after the vacation. What is the problem, my lord?
I don't have that.
She's having a problem. I don't have a problem.
She is, my lord, every council has problem from their clients, my lord. I have also problem from my client. But that
No, you're not free the after tomorrow.
Saturday.
No, Saturday, Friday.
Yeah,
Actually, Wednesday.
Friday I'll be out of it.
No.
Tomorrow evening. My apologies, my lord. My apologies.
My difficulty is that only, my lord.
Correct.
That is why my lord.
No, you see, she has been pressing for this case. She doesn't usually press.
Yes.
That's why I'm just.
In my case, my lord, in all the cases, she pressed like anything. In the
my
father's
lord, no.
case also, I had to face some sort of
No.
turmoil from my friend, my lord. In the father's case also,
No,
my lord,
my lord, that
she beaten me blue and black everywhere.
Okay, we'll listen after vacation.
And
You know
the
what to
school is
do.
closed, my
I'm
lord.
saying the after tomorrow. He's saying he's not free.
not available.
And I'm saying,
Why not tomorrow then?
Yes,
lord,
my lord.
What about tomorrow?
see, my lord, the
So,
school
hearing
is,
day tomorrow.
Huh?
1 second.
Oh. What about tomorrow?
The school is
Wait.
closed.
No. What about tomorrow?
Lordship will take up tomorrow.
I've got no problem.
Fine, my lord, let's take up tomorrow. Fine. Lord, I am not evading the case, my lord. I am very clear with that.
No, she's insisting. That's fine.
No,
Not on that day,
my lord,
I am-
she'll always insist. But
No,
the
my
thing
lord.
is that, my lord, the school is closed from 6th April to 17th May for summer vacation. So,
Okay. 6th April to 17th May.
yes, I have this, my lord. Then what is her difficulty, my lord? Otherwise also,
But
it's to,
some observation may be recorded
If-
in that order, my lord, today's order, my lord.
Again,
Otherwise,
observation.
it will take.
Alright.
my lord, In that case, my lord, what happened, my lord, the student was in class 10, my lord, when they approached before the court. Now he is in class 12, my lord.
some
So we did not
student,
take any, my lord.
some
Yes,
student, my lord,
that is the
this
position of
court
the school,
protected.
my lord.
my lord, some student, they get rid
Okay.
of this court protected.
No. You see, no. He's saying that there's a holiday.
Yes, my lord, that's it.
That's a holiday,
But
my lord.
some
And the school-
observation, my lord, endeavor shall be made to dispose of that on that.
Ah,
my
ah,
lord. That should be
I
strictly,
don't-
my lord, and that is only my. Because that is the, my lord,
He's
position of
going
the
to,
school.
his tactic will be to ensure that this case stays here. for a long time. So that by midterm, he'll say, now where will I get admission?
No,
Where
no,
will I get admission?
no, Milord. Milord,
And
why
that-
I'm saying so? No, no, let me explain. Milord, Milord, let me explain. If that case, the other case gets dismissed, my other lordship may not require to hear this matter. If my other case gets dismissed, I am compulsorily retired from the school. I cannot get my ward admitted into that school, Milord. So this case automatically goes. I cannot pursue this.
Not on the merit matter, because I want to.
My friends want
separate that
once a
matter,
day.
because we
Anyway,
were-
since there's a holiday since 17 May, because he wants to extend the
Yes.
time.
Because my lord, I have the experience of that case, my lord.
Okay, right. Mr. H.K. Das, learned counsel for the petitioner, strenuously prays for adjournment.
No, the affidavit in reply.
Just a praise for adjournment. Praise for adjournment. On the other hand, Ms. Again, learned counsel for the respondent, strenuously prays for hearing the matter as similar matters have been pending before this court, which has left the authorities in a predicament, in as much as they are unable to act upon the decisions made by them regarding the discipline that has to be enforced in the school. First up. On considering the fact that the school is going to be on vacation from
6th April to
6th
7th
April
of
to
May.
17th May, as stated by Mr. H.K. Das,
No, it's there, the document is there.
as stated by Mr. H.K. Das, and as the affidavit in reply is not on record, list the matter on, give a date.
29th.
Before that. Okay. When do you want?
22nd
22nd.
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 is available now.
22nd, I'm there. My sister.
And
is pulling
endeavor,
my leg, my lord.
an endeavor shall be made to dispose of the writ petition on the said.
Lord, the
Interim orders passed early shall continue till final disposal of the case.
My lord. Highly. Made previous lordship, my lord.
Item?
33, my lord. My lord, here, my lord, service is completed, my lord. My lord, matter may be, my lord, directed to after vacation, my lord, because.
My lord,
some
I am
urgent-
appearing for private respondent number 5, my lord. I will file affidavit, my lord.
You have filed,
I will file, my lord.
you'll file.
Who wants to file affidavit?
You have not filed. Then he's saying that pleadings are
No.
complete.
No, my lord. But is, if your service is complete.
Oh, service complete, okay, right. Mr. B.K. Das appears for the petitioner. Mr.
V. Borua for respondent 5.
B. Barwa for point number 5. Mr. For respondent number 1 and 2, and Mr. I. Alam for 3 and 4. Are granted 3 weeks time to file affidavit in the position. Release the matter after 3 weeks.
Lordship. Service is completed and they were supposed to file affidavit in deposition, but they did not.
I last order some affidavit was directed to be filed regarding service.
Lawazima court says that service complete.
Then the court's order is there.
2025.
Acha, after this, because no, but this is 22 and 25. Lawazima court order procedure.
Service completed.
Yes, Mr. A.R. Tapillar, learned counsel for
Higher education.
Higher Education Department is granted 3 weeks time to file affidavit. The Lawazima court order dated 22/1/25 states that Service in respect of the respondent number 3 and 4 has been completed. However, no one appears for the respondent number 3 and 4. List the matter after 3 weeks.
Nice.
No one appears for the petitioner. The petitioners. Office note indicates that para-wise reply has been received from the head teacher of the LP school. That is the respondent number 5. Yes, are you filing anything?
Yes,
When?
after 4 weeks.
Mr. G. Pegu is granted 4 weeks' time to file affidavit on behalf of
Respondent number. Elementary education. Man.
on behalf of the Elementary Education Department.
Yes.
This is the matter after 3 weeks.
36.
But as per laws in a court, when service on the respondent number it has completed. Here we go and praying for 4 weeks time.
Item 30,
36.
36. Mr. G. Pegu. Is granted 3 weeks' time to file affidavit in position on behalf of the Elementary Education Department.
Interim order is there, my lord, maybe.
Office note, no, the proceedings of the Lava Zima Court dated 19/24 indicates that service of notice in respect of the respondent number 5 has been completed. This is the matter after,
Interim order is there, my lord.
This is the matter after 3 weeks, interim order to continue till the next.
Obliged.
37.
What to do?
Petition not there.
No one appears for the petition on call. Mr. S. Bora appears for the SSA. Have you filed affidavit?
Yes, yes, it is in file, my lord. You are challenging a reshuffle of dated 10/7/2023. And there is no interim order. By now, maybe he has to join that particular place.
Okay.
Reshuffle only of 18 kilometers.
You obtain instructions?
That I can do.
Mr. S. Bora, learned counsel for the SSA shall obtain instructions as to whether the petitioner has joined his new place of posting as per the reshuffle that had taken place.
On 10/7/23. Order dated 10/7/23.
Right, order dated
10/7/23, my lord.
10/7/23. And this is the matter after the vacation.